Hey guys, good morning. Hey Nancy, Jelly Bean. Hey guys. Um, we have about 2.5 hours of the hearing within this trial, and then we will be back in the presence of the jury. Hey Carla. So we'll see. Let's do an hour and a half and see if we want to do 2.5 hours this morning and get done with this stupid hearing with the dumbest questions in history. Was it a tooth? Was it a fingernail? What difference does it make? Did they hide it? Who touched it? Was it in a glass vial? Who cares? It's getting old and tedious, and I want to get back to the trial. I want to know what happened to Lana Clarkson. So I'm ready for some real meat and potatoes and not this whatever crap they're doing. Nope. We got to take the good with the bad, the boring with the exciting. We got to do all of it. Hey, Flash fan. Yeah, at least it's not melting ice cream. Carla, be glad it's not melting ice cream. This is actually more interesting than the melting ice cream. And how? Tell me, please, how melting ice cream can be a timeline. Is there any scientific studies on how long it takes ice cream to melt? And especially in LA. What month was the OJ thing? July? It was like in the summer. I was so tired of hearing about that damn ice cream. I was so glad when they stopped talking about it.
Another witness?
We do, Dr. Pena, Your Honor.
All right.
Could we be heard
Yes.
briefly?
Yes.
And I'll say it this time, because you probably don't want to hear Mr. Jackson saying it again, but it's our same kind of, I don't think that we've really gone a little far afield here and we've lost focus of what I thought the main issue was in this hearing. We have Dr. Kenya and we have DNA coming in. We were to have a conversation back what's going to be offered before the court and told what was going to be offered. We might stipulate to that and save the court and everybody a whole lot of more stuff I want to know.
Let's have an offer proof.
Yeah, with reference to Dr. Pena, he was the pathologist who did the autopsy on Lana Clarkson. And my focus for talking gunshot residue in the mouth, the fact that he concluded it was an interoral gunshot wound where they gunned in the mouth, and there was abundant, massive amounts of soot, gunshot residue that was visible, etc. To examine the fingernails that are at issue, the broken nail and so forth, and there was no visible gunshot residue, soot, and he can explain in detail what that is and what the significance is. I believe it will be Dr. Pena's opinion that there was no evidence that there was evidence that the gun was in the mouth when it went off, and there's no evidence that the thumb with the broken portion of the acrylic nail was in the mouth at the time that the gun went off. And had that been the case, then there would have been, based upon all the other evidence, and some soot and debris that would have been visible, just like there was throughout the mouth. And he's going to explain that opinion to the court.
Where are you going with that?
Well, Mr. White says that he thought that there was, on this object, he thought that there was some quote-unquote bullet wipe on that fragment of whatever he saw. Whatever he saw, he thought it was bullet wipe. Mr. Jackson has impliedly made the assertion that if this was a result of a struggle, if it was bullet wipe, it would have been the thumb and the nail at the time it was blown off and broken. If that were to have happened, it would have had to have been in the mouth at the time, because that's when the gunshot went off. And so how that nail then gets out of the mouth is just improbable, and it didn't happen based upon the evidence that there's no soot or anything around the rest of the nail on the finger when the whole mouth is full of that. And so Dr. Payne sort of ties that together, and that's the focus of his testimony.
Well, here's the problem, and I tend to agree with the people on this. I think you're missing the point. There's really 2 points, and one I raised when I allowed you this morning to put on some evidence. Ultimately, if I determine that somebody removed a piece of evidence, one, there's just generally the question of whether there should be sanctions. There's also the question.
I have been trying to figure out what the heck they're talking about. I've never heard of bullet wipe either. And they keep explaining it, and it still doesn't make sense to me. It's some kind of residue that I don't know. I'm still confused about what bullet wipe is.
And certainly the credibility of anybody who took that, if it was taken, and I'm a long way from making any determination of that individual. If there's an individual who took anything, and if they testify in this trial, certainly their credibility may be impeached by that if we get to that point, and there's a lot of ifs involved. There also, and I guess when I determine if I ever get to that point that such a thing happened, and if I have to determine the sanctions, perhaps the severity of anything that was removed. And I understand it may go to that point, but we seem to be taking a long time without Dr. Lee testifying at this point. Yes, Mr. White offered an opinion as to what he thought it might be, but he can't say with certainty. He has a certain degree of certainty. And I think we're putting the tail before the horse, quite frankly.
Well, Your Honor, Mr. White did give an opinion, and that
Yes.
opinion is being,
Well, here's what we have. We have Sarah Kaplan. I think everyone has agreed that her credibility, and if not, you can let me know, that she saw something put in a vial and removed. Now, what happened? What's in the vial? What ultimately happened? Those are questions that still have to be determined. I didn't hear anybody really challenge her credibility.
yeah,
No, I'm not done yet,
Oh, I'm
please. Okay? So when we find out, so something was taken, whether it was ever ultimately, and perhaps we need to hear from Dr. Lee, maybe he'll come in, I don't know, and say, oh, this is what's in the vial. I gave that to the prosecution. Maybe we have a tempest in a teapot, and maybe we don't. And maybe there's other explanations. I don't know. I have to hear the testimony, and I have to weigh it against other testimony, and I have to make certain factual findings and credibility findings. But I think, I honestly get the feeling at this point, with due respect, that there's an attempt to put on certain evidence, not necessarily for my benefit. And you can think about that for a second. I think we're getting way offline and spending an enormous amount of time. And this isn't in front of a jury, it's in front of me. And this isn't the first case I've ever heard. Mr. Bruno.
Can I take a small swipe at the ball?
Sure.
This evidence is being offered to support Dr. Lee's assertion he didn't pick up a piece of fingernail into detective or former detective.
Was it Dr. Lee? How did you know what Dr. Lee's going to say?
Because he's already said it.
To who?
To the defense. This is not the first time. This is a reprieve. This is like Batman 2. We've been through this already.
Not in front of me.
Well,
You have some testimony? You have some testimony you want to show me? Has this been?
No, it's statements that
Well, how would I know about those statements?
I'm telling you about it.
For the first time.
It was the first time. I don't mean to be flip about it, but we tried to say this the other day and didn't get it articulated. This has been a moving target. You have to admit that,
It's been raised before.
right. But no, I mean, this whole hearing, we've kind of gone from subject to subject, and the focus, keeps getting refocused. I mean, the people have commented upon that earlier today, is that it wasn't clearly defined, which was the problem we had to begin with. However, Detective White, former Detective White, ex-detective, to the extent he has any credibility at all, there's only one partial fragment of a fingernail missing. He said, I saw what appeared.
That's not what he said. He saw something consistent with it.
Something consistent that had something consistent with bullet wipe on it. And if there's any assertion that the missing fragment was that, this will completely impeach it, because Dr. Pena will say, if that had been knocked off by a bullet or by a gunshot blast, it would have evidence of wipe or bullet on it, on the remaining thumb. So, I mean, it impeaches White's observation insofar as that has any credibility. It also, we contend, will support Dr. Lee's mention. He never picked up a fingernail, and White was just incorrect.
Well, what did Dr. Lee pick up? As long as you've raised this, and apparently you've talked to him, do tell me, what did he say he picked up, if anything?
Well, I'm going to give you multiple layers of hearsay, but I will answer.
That's fine, we'll take it at this point.
Because there was a bit of fabric and a bit of tissue, a bit of fiber that's been turned over to them months ago.
2 items. They're in packages.
They have what he picked up.
Have you ever shared this with prosecution?
Yeah, they
have it.
They gave us pictures of it this morning. We asked them, this is what we're trying to get released for testing. That stuff that Dr. Lee gave them about, 6 months ago?
Let's pull the pictures out and show the court what the pictures are that Dr. Lee says he picked up at the scene. I mean,
Okay.
but why dance around it?
No, I got the pictures. They're somewhere in my pile of stuff.
Well, tell me what it is.
Well, there's one that looks like some fiber material, fibers, whitish fibers, and there's it's described in Dr. Lee's notes, because Dr. Lee's notes indicate he collected 2 things. One is this clump of fibers, and there's pictures of it. It's hard to describe, but with white fibers with maybe some blood stains on it that was near, well, I don't know exactly where it was near. Then there was, on the stairs, there was what appeared to be some type of a blood stain that he picked up in crusted form, and now we've got a picture of it. It's just broken up little pieces of what looked like blood. That's what we were asking to get released to be DNA tested to determine for sure if it was Lana Clarkson's blood. We think that that's the item that possibly Mr. White and Dr. Lee were discussing, and it doesn't seem to comport with Ms. Kaplan. In other words, we're not sure what she was talking about, because if I correctly remember her testimony, she said she saw a white object about the size of a fingernail. And I just don't know what the explanation is for that observation. But Dr. Lee's position, and it has been all along, we went over this with Leslie Abramson, is that right when they were going to have a hearing, Dr. Lee came in and he was about to testify, and then the hearing got pushed off or canceled or whatever. He will very clearly say he never collected any fingernail or part of a fingernail or acrylic type fingernail at that scene. He collected the 2 items he documented in his notes and photographed that's been in the possession of the sheriff's department for some time now. That's all he collected. He observed them.
What did you do?
He packaged them up, pictures of the packaging at the scene, and he retained them until the time they were sent to the sheriff's department.
Okay. I'll hear from people. Thank you.
Actually, Your Honor, I think I can short circuit it. You don't need to hear from us. I think the court should ask to look at those 2 photographs.
I'd like to see the
We've all
photographs.
heard what's been described very, very definitively by Sarah Kaplan and very, very definitively by Stan White. Let's take a look at the photographs of what Dr. Lee says he picked up.
Just show them to me.
Well, we actually sent somebody to the 17th floor to bring him down, if that's valid.
I've got them somewhere here.
All right, why don't you take a look? In the meantime, while you're looking for the photographs, what is your position on the defense reason for calling Dr. Pena?
I don't think it speaks to the issue. If they're trying to debunk the idea of exactly what this is, in other words, they're trying to prove what the item is not. Again, going back to the arguments that we made this morning, that doesn't get us any further to determining what, if anything, Dr. Henry Lee took, if he took anything at all. I mean, we've got 4 out of 8 people now, 4 out of 8 people who were determined to be at the crime scene saying something was taken. Sarah Kaplan, Greg Diamond, who was corroborated, understandably, there are differences in their testimony, but Sarah Kaplan, Greg Diamond, Stan White, and Robert Shapiro all indicated at one time or another that something was taken from that crime scene. That's half the people that were there. All we're trying to figure out is what was taken. Not that what Stan White may have seen is scientifically inconsistent with his opinion or belief about what he saw on that tissue in Dr. Lee's hands. And I think that's where we're going. I think this is an opportunity for the defense to present their science, not to this court, because it's not really the issue, but to the media. And I don't see it as being relevant to this inquiry.
They contend that the nail was collected by Dr. Lee. That was the subject of the previous hearing that never went forward, even though, as the court heard, Mr. White was flown from Iraq. Dr. Lee was flown in. He was ready to testify. The actual letter the other day, and just turned that over, but that was basically, she represented to the court and counsel at the time that Dr. Lee was here to say, I didn't collect any nail, and he was ready to testify, and then they canceled the evidentiary hearing. Now, why they did that, I don't know, but they contend that this nail was collected by Dr. Lee. That just didn't happen. And part of the proof that we have for that is the testimony of Dr. Pena and Steve Renteria, who was at the Sheriff's Department crime lab, because he analyzed all the nail. He did an analysis, both DNA and also presumptive blood testing, on that. And he's able to testify to that. And he also was at the crime scene and he searched the areas where this is allegedly happened, because you have to assume that everybody else missed it. There were 30, 40 people who were at the crime scene. A lot of them, there was a group of people, according to the records that we have from the Sheriff's Department, that searched this area and all areas of the home for many, many hours. And you have to believe that they all missed something that Sarah Kaplan, missed something of evidentiary value that Sarah Kaplan all of a sudden just saw in plain sight. And we think that once the court hears all that evidence, it's illogical to believe that it's the nail or any other relevant piece of evidence.
Here's what you may do as the following, please. I need everybody's attention. Will the people stipulate that both Dr. Pena and Mr. Renteria are suitably qualified to offer the testimony that they're about to offer?
Yes.
All right. So we don't need to go through any foundation.
That's fine.
You may call Dr. Pena and specifically, based upon your offer of proof, ask him about the fingernail, and he can offer certain opinions so that the court can make a determination as to whether whatever it was that Mr. White saw may or may not be a fingernail. Understandably, that's not conclusive as to whether anything else was taken, but it helps me focus on what the evidence is. It's limited. He may be called to testify as to the search he's aware of in the area where Ms. Kaplan says she saw something recovered, so that the court may determine whether indeed something would have likely to have been missed, or the objects that everybody is claiming they may or may not be were missed. That's what we're going to limit it to, because that's what's relevant to the hearing.
I agree. Thank you.
All right, thank you.
Dr. Pena.
Absolutely. You solemnly swear the testimony you're about to give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please be seated. Would you state and spell your name for the record, please?
Luis Pena. First name is Louis. Last name is Pena.
Thank you. You may proceed.
Dr. Pena, I want to direct your attention to the 1700 Grandview Avenue in Alhambra and the date of February the 3rd of 2003. Did you go to a death scene at that location?
Yes.
And you saw a body of Clarkson, later identified to you as?
Yes.
And when you were at the death scene, did you make observations of her body?
Yes.
And later on, at some point in time, did you conduct a post-mortem examination of that body?
Yes, I did.
Did part of your review of the body at the death scene, as well as the autopsy, include examining the hands of the decedent?
Yes.
Did it also include looking at the mouth or the oral cavity of the decedent?
Yes.
And when you looked at the mouth or the oral cavity of the decedent, did you notice any black material that you recognized?
Yes.
What did you notice? What did you see?
The first thing I noticed on her hard palate or the top roof of your mouth was some black grayish debris. At the time, I did not know what it would turn out to be. Later, it's identified as sooting. I also noted at the top of the tongue where the stellate laceration was seen by myself. There was also gunpowder debris embedded in that muscle tissue of the tongue.
Okay, I'm showing you what's been previously marked as exhibit number 9. Is that a diagram that you made of the material in the areas that you just described?
Of the tongue, yes.
Okay, and you said soot. What do you mean by soot?
Well, it's when the gun is discharged and the bullet is traveling out the muzzle, it'll leave a blackish grayish debris depending on how close it is to the target it's going to hit. So the closer you are, the debris, the black debris will be deposited on that in that area, whether it be skin or in the soft tissue in this case.
Okay, and just to cut to the chase, did you conclude that this was an intraoral gunshot wound?
Yes, it was.
And define it for the court, if you will, briefly.
Well, that's based on a number of factors. One, as I just described with the sitting debris. The other is the weapon was test fired by Mr. Steve Carroll of the LA Sheriff's Crime Lab. And he put the distance approximately 2 to 3 inches when it was in the mouth from the ultimate target it's going to hit, which is the back of the throat. Based on that information that the gun was in the mouth.
Okay, and what's the court's next in order?
Next in order will be 16.
Number 16, showing you this diagram, Dr. Pena. Is that another diagram from yourself?
Yes, it is.
Is that the trajectory that you, of the bullet path?
Well, that's the direction as it strikes the intraoral at the back of the throat. It's a very crude drawing, but it gives you a basic direction of, as it's stated, it's front to back and slightly upward, but that is through the tissue only.
Okay.
Can I ask you, you speak almost as fast as I do sometimes. Can you slow down a little bit?
I'm sorry, Your Honor. Yes, I will.
It's not for me, it's for the report.
Okay, sorry.
All right.
Now, Dr. Pena, based upon all the information that you had, you concluded that the weapon, in this case a .38 caliber, was in the mouth when the shot was fired. Is that correct?
Yes.
And in addition to what you've already explained as far as the basis for your opinion, was there some dental debris that was broken off after the gun was fired?
Yes.
Okay, explain to the court what that was from your observations.
From my observations, those are the two upper teeth of Ms. Clarkson, known as the central incisors, that due to the, in my opinion, to the recoil and perhaps part of the blast effect when the gun is fired, the recoil demonstrated with my hand, this type of motion, went up and struck the two upper front teeth, and the teeth were ejected out.
Okay, and were there any teeth that were blown inwards?
No.
Okay, and was all through the mouth, or in the inside of the lips and the cheeks and everything, was there a lot of blackish gunshot type material?
Actually not. Only in the one area called the hard palate, which is the top roof of our mouth, did I see a grayish debris.
Okay, did you see pseudo-stippling?
Yes, I did.
What is that compared to the actual other material?
Pseudo-stippling, by definition, basically implies a bullet went through another object, whether it be glass, whether it be a screen door, car door, etc. He's here, the effect of this gunshot wound, meaning the bullet didn't strike the teeth, strike the teeth directly, but as a result of that gunshot wound, the teeth fractured, blew out, and as a result of that, they struck the inner parts of her gun line and the buccal mucosa, we call it, or the intraoral part, and it left little shards and caused lacerations or cuts. And that's what I was seeing. And that's described as pseudo-stippling.
Okay, now I want to now focus on the hands of Lana Clarkson. Now you were actually at the scene in addition to doing the evaluation.
Yes.
And I'm going to show you what's been marked as Exhibit 14. And this is not a very good picture, but it's a picture of her right thumb. Did you have a chance to look at that at the same?
Yes, I did.
Did you, or could you tell from looking at the mouth that there was a gunshot in the mouth? Did you see any blackish soot type material on her right hand when you were at the scene?
Not grossly.
Okay, and when you got her, the body, in this Exhibit 7, we got the body to the medical examiner's office. Did you have a chance to look at her hands and her fingernails?
Yes.
Okay, and here, this is a picture, Exhibit number 7, of her right thumbnail. Is that correct?
Yes, it is.
And was there any part of a right thumbnail that you saw was defective in some way when you made your observations of it?
Yes, there was.
And what was defective about the right thumbnail?
Well, if you look at the picture, her normal nail, natural nail is the one without the color. She had a white acrylic, in my description, nail, and it's diagonal crack that you can see in the photo. That's the acrylic part with the white tip portion also missing. But the natural nail that she has is underneath that. That was intact.
Did you see any damage to the natural nail?
No.
The portion of the nail of the natural nail where the acrylic is present, does it appear to be contiguous? In other words, does it match up together and flush up together?
Somewhat it does, yes.
Okay. And have you ever heard the term bullet wine or lead residue comes to material or objects or anything like that?
Yes.
Have you ever, in your experience, ever seen that doing an autopsy?
Yes, I have.
Did you see any of that on the natural nail or any portion of the acrylic nail that was still on the decedent's right thumb?
Not grossly, no.
Okay. Did you see any type of gunshot residue or soot tattooing or anything such as that?
No.
Okay, and did you carefully look at the fingers and nails and so forth regarding that?
Yes, I did.
Okay, and let me ask you this question, Dr. Pena. I want you to assume the conclusion that you came to with reference to the shot that killed Lana Clarkson, that the gun is in mouth, a couple of inches, or what's your...
Well, from the muzzle point of that gun to the eventual target, which is the back of the throat, it was test fired anywhere from 2 to 3 inches.
Okay, so it was in the mouth, and you knew that the side of the gun had to be in the mouth because that's what caught the tooth, correct?
Yes.
Okay, and I want you to assume that the decedent's right thumb was in the mouth in front of the muzzle of the gun, the bullet end of the gun. Would you expect to find some type, based upon what you saw in the mouth, would you expect to find some soot or markings on the nail of the thumb, if in fact that were true?
Jackson, that may be beyond his expertise.
Well, first of all, I'll ask, are you able to offer an opinion on that?
No, I'm not, Your
All
Honor.
right, the objection is sustained.
Did you see any evidence on the decedent's right thumb that her thumb was in the mouth when the gun was fired?
Same objection, Your Honor.
Can you offer an opinion on that?
No.
The objection is sustained.
Thank you, nothing further?
Thank you, Cross.
No questions.
I'm not sure you can answer. From your standpoint as a coroner, let's assume that you had that piece of missing nail. Would it have proved valuable to you? Would you have been able to use it for some purpose of yours?
Well, from my experience, that nail would have been valuable to correlate it with the remaining nail that's there. And if they're sitting present on that absent piece, I would expect to find that on the nail. Likewise, if it's absent, I expect the natural nail to be absent also, along with the acrylic.
Any other purpose that it would have been valuable to you?
No.
All right, thank you. Any further?
Yeah, quickly, along the lines of the questions that the court asked, when a self-inflicted wound is done with a handgun, such as the one used here, is there evidence in the medical literature that sometimes a nail is broken during that process?
Objection, this is irrelevant. This hearing, it's completely irrelevant.
Well, it's relevant to me in a limited fashion. I've talked about if I ever get to that point of determining if any evidence has been taken, what its value was, what the sanctions should be. It has some tangential relevance that I'm going to allow him to ask the question.
And I believe, to interpose a second objection, I believe that it assumes facts vastly, not in evidence.
Well, this is a hypothetical. And again, a hypothetical is only as good as the assumed facts in the hypothetical. And if it turns out they're not there, the hypothetical is worthless. All right, you may proceed.
I'll re-ask the question if I can.
Can you remember it?
Yes, I can.
Otherwise, Mr. Jackson's objection was cleverly designed.
Just have to be reread.
All right.
Yeah, in the medical literature regarding self-inflicted wounds, one of the things that is studied in the line of work that you do, determining manner of death, is features or characteristics of what you might want to look for regarding a self-inflicted wound versus some other type of wound. Is that correct?
It's very weak, to be honest with you, but it is in some of the some literature articles that I've read.
That whether or not a nail is fractured or broken is something to at least consider regarding a self-inflicted wound.
To be honest with you, I've never seen a single article with that reference to a nail on a self-inflicted gunshot wound.
Have you ever, in your experience, had cases where nails are broken, where a determination is made that it's a self-inflicted wound?
Never seen one.
Okay, very good. Thank you.
Thank you.
We have a meeting.
Okay. All right. Anything further, anybody at this
No,
point?
thank you, Dr.
Thank you for being here. You may step down.
Thank you, Your
All
Honor.
right.
Steve Renfaria.
All right. It's ready.
That is BS. If the gun, what did they say? The trigger hit her nail and it cracked it, it would have taken off the whole nail, not just the acrylic layer over top of the natural nail. As someone who very frequently wears acrylic nails, a hard force like that will not just crack the acrylic, it will get the whole nail. Why is this not working? Stupid StreamYard. Okay. Really? I didn't know that. Um, this guy's last name is Renteria. And every time I hear this, it's not a common last name, but every time I hear it, do you guys remember the Carol Burnett show and how she would come out and ask the audience questions at the beginning or let them ask her questions? There's this one girl that asked a question, raised her hand, and Carol Burnett asked her name. And it was Teresa Renteria. And Carol Burnett said, "Oh, what a nice name. Teresa Renteria. Teresa Renteria. Teresa Renteria." So now every time I hear that last name, I always think of that. And I'm like, Teresa Renteria. So I've been doing this every time I hear this guy's name in this trial. My brain always goes, Teresa Renteria. Teresa Renteria. So if I giggle when anytime this guy's name is mentioned, that's why I'm giggling.
Job is with the Sheriff's Department as of the 3rd of February 2003.
I'm a criminalist or forensic scientist for the Sheriff's Department, and my main function is DNA analysis in laboratory. Also, or I have also done collect investigations with detectives need assistance in locating evidence, documenting, and collecting.
And were you the criminalist who responded to a scene at 17 Grandview Avenue in Amber on the 3rd of 2003?
Yes.
Was there a criminalist that responded from the Sheriff's Department in your laboratory?
There was one other criminalist that I had called in for assistance. His name is Robert Kyle.
Okay, and were there other people that were assisting you in the collection of evidence that you were supervising at that scene?
Well, the detectives were present, and obviously we were working under their direction. And at a later point, the coroner sent a of investigators in for processing the body at the scene.
Okay, and just to, if I understand, were there two different roles between the coroner's people and your people from your laboratory?
Yes, that's the normal process when investigating a homicide. Any evidence on or with the body or the decedent is the responsibility of the coroner's office, and anything that is not on the victim or the decedent is the responsibility of the crime lab or the detectives working the case.
Okay, now, in addition to the criminalist that you said, Mr. Keel, Keil, that assisted you, were there also forensic identification specialists that worked with you in order to search for and help identify and collect evidence?
Well, they actually have other functions there at the crime scene, mainly photography, crime scene documentation as far as sketches of the crime scene, and also for fingerprint or latent fingerprint examination at the scene. There's two different roles.
Okay, and the decedent was found in a foyer area of the home, is that correct?
Yes, sir.
And was the foyer area, was it searched for evidence to your knowledge?
Yes, Your Honor, if I find the court's patience here. If this witness is here to say that he and the others made a good search, even a comprehensive search, it doesn't make any difference if Dr. Lee picked something up and pocketed it.
Well, but it does in the overall picture. It helps me determine whether it's likely that he did or did not. We have testimony, some of it may be uncontradicted, but also as to what it was, as to what it, if it's what it's purported to be by certain individuals, whether it's likely it would have been overlooked. Those things are all relevant. And I'm quite willing to hear it. You may proceed. If the objection is overruled.
Just briefly, Mr. Renteria, with reference to the coroner's people and your staff and the two criminals, including yourself, do you work together to process the scene to identify and collect evidence that might be useful in the investigation of the death?
Well, again, the coroner has a different function there in collecting evidence off the body. Now, we may be present when that is happening. In this particular case, the area was so large. I was in the area when the coroner team arrived and started doing their assessment, but I wasn't necessarily standing there with the coroner's criminalist or Dr. Pena at the time when they were doing their collection from the decedent.
When you were there, were you the person in charge as far as the sheriff's department personnel?
Well, I was in charge of myself and Robert Kyle. The detective is in charge of the crime scene.
Would the detective be looking for evidence and then giving you information as to what you might want to look for, collect, et cetera?
That's correct.
Okay, and would the foyer area where the decedent was found, was evidence looked for in that area?
Yes.
Okay. Now, this morning we had testimony from one of the coroner's body processing evidence persons that she noticed a defect on the right thumbnail of the decedent. My question is, did you observe that?
I don't recall that myself, no.
Do you recall her telling either you or one of the detectives that one of the nails or portions of the acrylic nail was broken on the decedent's body? Do you recall that now?
I don't recall that.
When you look for evidence at the scene, what evidence were you looking for?
Well, it's basically anything that looks like it might be potential evidence. Obviously, we don't know if it's evidence right at the point, but we try to look at things that are out of place, that maybe weren't there before the incident occurred, then determine at that point if we think it might have evidentiary value, then collect it at that point.
Okay. Who searched the area where the decedent's body was in general, if you know?
I know I searched the area myself. I think Robert Kyle or Bob Kyle, who assisted me, was also there. And I don't know, but I would imagine the detectives present probably were looking in that area too.
Okay. This would include the area around the body as well as the area between the stairs and the body and the stairs themselves?
Yes, sir.
Okay. And give the court an idea of, how thoroughly you searched. Did you just walk around and look, or did you sort of go through, like look at each step, for example, up the steps, et cetera?
Well, the main examination area was the foyer where the victim was present, and also the lower stairway just in front of the victim. We did look at the steps walking up one at a time. We did notice some white material on a couple of the steps in that area. We did notice also some white material and wood fragments on the floor of the foyer in front of the victim. Some taser wires and taser darts that were also present. The carpet in the foyer was a dark red burgundy type color. So finding the white fragments and the wood fragments and the taser wires were fairly easy because it was very obvious that they were there. And then we were also looking for any additional blood stains that would be present away from the body that might be later on collected.
It would be easily identifiable on the carpet. You looked at the carpet between the body and the wall of the stairs, I take it. Is that correct?
Yes.
In fact, you found some wood chips and some white particles that later turned out to be dental material in that area. Is that correct?
That's correct.
And then you also found some on the stairs, kind of up, but in the same direction as to where the other ones were, correct?
Yes.
And did you look at the area that was between and the wall? In other words, like in that particular area?
I'm sure which area you mean.
Okay, the box, let me get a picture here. What's the next one?
Next one.
Showing you on the overhead here. Do you recognize this scene here?
Yes, I do.
The 4 and the 5 is where the white objects of dental material were found, and some wood chips. Is that correct?
If I may refer to my report real quick.
Please do that.
Number 5 is the area where the light material and wood fragments were found. Number 4 was in fact a deadbolt lock handle that had come off the deadbolt from that door.
Okay, so 5 is the white objects that you talked about. And on the stairs, do you see this little item right here? Is that another piece of dental material?
Yes.
And you thought it was important, 4 and 5. Did you search this area where this baseboard is between this pedestal and behind the door and search that particular area?
Yes.
How carefully did you look at that for, let's say, white objects that would have been visible to you?
Well, we would have looked just as closely as we would have when we found the white fragments. While we weren't on our hands and knees, opening the pile of the carpet, but we did have flashlights and we looked carefully to see if there was anything obvious on that carpet.
Now, these little whitish objects that were ultimately turned out portions of dental material, they were smaller than my thumbnail, were they not?
Yes.
Okay, they were maybe a tenth of the size of my thumbnail.
They were smaller than your thumbnail. I don't know the exact size.
Okay, and was there also a lot of whitish medical debris that was there from the paramedics, little white patches and things of that nature from putting on EKG pads and things of that nature?
Yes, sir.
Okay, was there, that's not something you were interested in as evidentiary material, is that correct?
That's correct.
And why was that?
Well, we know the victim in this case was worked on by the paramedics, and going to crime scenes, you become aware of what paramedics usually use to try to revive the victim, and it was obvious that's what it was. We didn't.
Little patches and things of that nature that they use.
Yes.
Okay, now you would not have collected those and thrown them away, you just left them in place or ignored them basically, correct?
Yes.
And with reference to this area where I'm pointing to now regarding the stairs, did you search this area, the stairs, and around this pedestal, maybe?
What was under it, but what was obviously seen by your regular eye as you were walking around there is what we examined.
Okay, now there was a little defect here in the wall where there was some wood, correct?
Yes. We didn't do a wood analysis or try to determine how it happened, but common sense, we did find some wood fragments right in that area. So to me, it appeared it would have been pieces of wood from that defect that fell onto the carpet immediately in that area.
Okay, you collected all of that, is that correct?
Yes, the wood fragments.
That was a little harder to see, I take it, than the white objects, correct?
No, they were visible against the color of the carpet.
Okay. And you searched in front of the stairs and up the stairs, on the banister, et cetera. Is that correct?
Yes, sir.
Now, I want to show you next in order.
18.
18, and the decedent was in a chair, and you can see her in the foreground right here. Is that correct?
Yes.
And item 6, do you know what that was from your records?
That was part of the taser hardware
Okay.
that was on the carpet.
And near the decedent or under the decedent was a pool or several pools of blood. Is that correct?
Yes.
Okay, I want to show you an enlargement of that. This is, sure. There we go.
Is that something you need marked?
March it.
18.
That's 18? All right.
This is the. For this year. Now,
You want to put that on the record, so for the reporter?
yeah, for the record, we'll stipulate that Exhibit 18 are the pools of blood that were under the decedent at the death scene.
For purposes of this hearing,
For purposes of this hearing, right?
we'll join.
Now, Do you remember seeing this pool of blood as the criminalist? Do you remember looking at that in general?
I observed the pool of blood, which was on the right side of the chair, below where the victim was slumped. It was a large pool of blood, fairly thick. I did look at the pool of blood. However, I did not make an attempt to go through the clottings of the blood and sift through it with gloved hands to see if there are any items in there. I did not do that.
Okay, and at the time that, how long were you at the scene approximately, best you can recall?
Probably at least 7 to 8 hours on the first day. And then on the second day, probably maybe 4 to 6 hours.
And all the evidence that you felt had evidentiary value, was it collected at the scene as far as what you could find?
Yes.
Okay, and did you collect this blood stain that was under the decedent?
No.
And at the time, did you feel it had any evidentiary value?
No, I did not at the time.
Okay. It was pretty obvious that the victim bled and bled on the carpet, correct?
That's correct.
Okay. Did you clean the blood up before you left, or did you leave that to the owner of the residence?
We don't clean up the blood after a crime scene. It's left to the owner of the house.
Can I suggest we focus again on the objects that are being questioned? I think get more to it.
Well, Mr. Jackson has raised a question about, and that's an issue.
All right.
I don't know why.
Briefly.
Thank you. Were there, okay. Looking at, can we have this marked next in order?
19.
Looking at the top picture here. Why I can't get this in focus here.
I assumed it was my vision. I feel better.
Focus area.
How do you focus? Let's get to Mars.
Let's refocus your writing.
Is there a button that does the focus?
Can we have the district attorney's expert?
Mr. Dixon's eyes are, it looks perfectly clear.
You just have to give it a minute.
Oh, you gave it a minute?
Yes.
Okay, you have to.
Don't put
There it
it
is. It's fine.
There it is, okay.
Good work.
Now, you recognize the top photograph of exhibit 19, I take it as this area that we've been discussing, is that correct?
Yes.
Okay, and I want to focus your attention on the non-carpeted portion of the stairs. There appears to be some non-carpeted portion of the stairs. Did you look at that non-carpeted portion for evidence?
Yes.
Okay, did you find any evidence there?
I did not collect any evidence in that area.
Okay, and to the extent there was evidence that you felt was of evidentiary value, did you collect it?
No, if I understand your question, if I felt if I saw something that had evidentiary value, I would have collected it.
That was my question. I maybe inartfully asked. I apologize. Now, did you collect any evidence from this, I call it the molding, down by the molding, either blood or blood spots or anything like that? Did you make any attempt to collect anything in that area?
No.
Okay. Did you see any blood in that area?
I did not see any blood in that area that would have been, in my mind, of evidentiary value based on what I would have already seen, documented, and collected.
Okay, I'm trying to understand what you mean by that. Could there have been blood there, but you just didn't think it was significant, or was there no blood there? Is that what you're saying?
That's right. There could have been a blood stain or an area that had blood, but based on the items where I had already collected and tested with our presumptive blood test, I feel it was an item that would lead or have evidentiary value.
I see. Okay, so I see a stamp on this somewhere, and there's 10 stains. You may test a couple of them collected, but you don't collect every one. Is that correct?
That's correct.
Okay, so you basically sort of, you collect enough to answer whatever question there might be as to the blood stain, and then you leave the rest because it's redundant essentially.
That's a possibility, yes.
Okay, and with reference to the wall on the stairs, did you look at that for blood and collect any blood, if you can recall?
Yes, I looked very closely at that wall. In fact, that was one of the reasons we went back, myself and other individuals, the second day, to try to determine if there could have been other blood stains that we did not see on the first day that may have evidentiary value. And if we did recognize those on the second day, then obviously they would have been documented and collected.
Okay, so for example, on the stairs, well, let me lay a foundation. You went back the second day and you essentially sprayed a chemical known as luminol to see if you could identify any blood stains that you weren't able to observe the first day, correct?
Well, at this point, I'm going to check. It doesn't appear that any discussion of luminol or blood stains.
The only reason it's being relevant, excuse me for interrupting, is again, it goes to Ms. Kaplan's testimony, and it's not that anyone's claiming that she's not being truthful. It goes to credibility. She said she saw certain observations that she had people look at, and the question is whether this witness also observed them. In trying to establish an overall picture, it is useful to me.
Okay, then my question was, you went back to the scene after you had searched it and done your visual examination, and when you did your first search, you actually had alternative light sources that you used, correct?
No, with the first search, it was a visual search, and then we also had flashlights to assist us. I don't believe we had an alternate light source, or at least I didn't, for finding evidence.
Okay, how many people searched in this area between where the decedent's body was, which was right here where I'm pointing, and this area, from the door to the end of the stairs? How many people were looking for evidence in that general area, other than yourself, if you know?
Objection big is the time, which day?
To that extent, I'll sustain the objection if you want to break it down by day.
Okay, when did you get to the scene approximately? What time?
I believe it was around 1400, 2 o'clock.
And during the daylight hours, correct?
Yes.
And you stayed there initially for how long?
Again, I think it was the first day, anywhere from 7 to 8 hours.
Okay, and then you came back a second time with some other individuals, is that correct?
Yes.
And what did you do the first time? Did you search that area along with other people, or did you do it by yourself?
I know myself and Robert Kyle would have searched that area. I'm not sure of how many more people.
And the detectives were involved in looking at this area too before you got there and after you got there?
Or I call for speculation before when he was
Sustained.
I'll withdraw. Mr. Kyle is a criminalist trained similar to yourself, I take it?
Yes.
Okay. And did you look for any blood stains on any areas of the stairs or the walls of the stairs?
Yes.
Okay. Did you found some blood stains, a blood smear on the banister, stair banister, is that true?
That's correct.
Collected that. Did you see any blood stains on any of the carpeting portions of the stairs?
No.
Would it have been hard to see that or easy to see that from what you could tell?
It would have been difficult depending on how much blood was there, again, because of the color of the carpet. There were some areas, even on the first day, I believe, that maybe were a little darker than the regular color of the carpet that I tested with our presumptive blood tests. Any of those areas that I did test came up negative. And then the second day with the chemical you've discussed already, there were no additional areas that I felt had evidentiary value for collection.
Okay, and that was with the luminol, and you did the carpeting, is that correct?
Yes.
Okay, and you did all the carpeting, but did you do the carpeting of the foyer also?
Yes, one of the main reasons we did the luminol was to see if there were any blood stains, blood spatters that we could not see that would be directly in front of the victim in that carpeted area. So that was the main reason of doing the luminol.
And would this luminol be able able to detect small?
Yes.
Did you find any blood spatters on the wall, or did you just luminol the wall?
I did not see any stains that, based on my experience visually, that looked like blood, where I would have tested them even before the luminol with our presumptive blood test, which we call, in short, KM test. Castlemeyer, that's correct. And the luminol examination, if we're talking specifically about that vertical wall, which is all wood panel on the lower part of the stairs, no area gave a positive luminol reaction.
Okay. And how about the stairs themselves, the wood area of the stairs?
That, again, I did the carpeted area. I am not sure if there was any stain or any area directly underneath that handrail of the stain that I had already collected. I don't recall if there was or if there wasn't. If there was a stain directly below that handrail, I may have not, or made the decision that was not of any evidentiary value because it would have been directly below the stain I had already collected. And what I was looking for, again, is additional stains in any other area where I knew I had already looked and didn't find blood in the first evening of the exam.
Okay, so just to kind of wrap up and summarize to make sure I understand your testimony, when you did the luminol, were you looking for blood to determine, like, let's say if the body had been moved or something like that, or for whatever reason?
Yeah, the luminol test is very, it's useful at times, not at every scene, but it helps us determine if there was any smears of blood, especially with this type of color of carpet that you just couldn't see, with the light, of any light smears. In your example, if there was dragging, luminol is very helpful in picking that up. Basically anything you can't see with a regular flashlight, your regular eyes, even during the day, luminol is useful for it, and that's what it was used in this case.
Okay, so even if it's not visible to the naked eye, if somebody that was bloody was maybe dragged across a carpet, you couldn't see anything, the luminol might illuminate that and alert you to that area, correct?
Yes, in that scenario, if there was blood that was smeared lightly across, even though we wouldn't see it with our eyes, and if it was still there, the luminol should detect that and give us a positive reaction.
Okay, and now this wall that was on the stairs, did you do any KM testing of any spots on that proved to be negative?
No, again, a visual exam was done first, and I did not see any spots on that vertical wall that gave me an indication that it could be blood, and therefore no KM test was performed before the luminol.
Essentially, the protocol and the scientific procedure that criminals like yourself follow, that if you see a stain that you suspect is potentially blood, you do this KM testing, and if it turns out to be positive, then that gives you the possible conclusion that it is blood, and you collect it, correct?
That's correct. If we believe that stain has additional evidentiary value from what we have already collected, we may not collect it. I'm sorry, if it does have value, we would collect it. If it doesn't add to the evidentiary value of stains we already collected, we may not collect it. But you're correct, we would do a KM test, and if it did have value, we would document it and collect it.
Okay, and the chemical in the Castlemeyer test is phenolphthalein?
Yes, sir.
Okay, and if you could tell the court, does it have a sensitivity of anywhere from 1 in 10,000 to 1 in 100,000 dilution of blood to, in other words, it can detect extraordinarily sensitive deposits of blood that are not visible even to the naked eye?
Yes, it's very sensitive. The phenolphthalein or KM reagent that we make in our lab usually gives us a sensitivity anywhere from 1 to 1,000 to 1 to 10,000 and sometimes even further out. So you are correct in saying you could have an area that might be positive KM that you wouldn't be able to detect it visually,
okay,
just by looking at it.
And once you get a positive KM result, that is what's called a presumptive blood result. Is that correct?
Yes.
And then you would want to take it further to get more information, doing additional scientific tests if you chose to do that, correct?
Correct.
When you did the luminol, did you see any areas around the body that fluoresced?
The only area that fluoresced around the body was the pool of blood. that was left at the scene.
Did you see any area on any of the steps, the wooden portion of the steps? Did you see any area fluoresce with the luminol?
I did not see any additional areas that would have added any additional value from the stains I had already collected.
Okay, and just so I can understand, would that mean that you did see areas that fluoresced, but that you had already been alerted to them based upon your previous investigation?
Yes.
Okay, so did you see, for example, the banister where you had collected the blood, did you get some fluorescence from that banister area?
The only area that gave a positive fluorescence with the luminol was that very bottom portion of the banister where one would put their hand, let's say, to pull up and come up on the steps.
Okay, would that be the area I'm pointing to now?
Yes, sir. There was a fairly large smear of blood on top of that rail that actually was discontinuous as far as the density of blood that was on it. And it actually almost kind of dripped over the edge of that banister. And that item, I think we identified as number 9. Now that gave a positive KM reaction the first day, and I had collected, documented, photographed, collected. I also sprayed, as far as the banister is concerned, the entire length all the way up to the first landing and across to the second set of stairs. I didn't go above that, however.
And was that because you weren't getting any luminescence?
That's right. The only part of that banister that gave a positive luminescence was item 9, which was the blood stain that was on the very lower end.
And how about the stairs themselves? Did you spray the stairs with luminol?
Yes, I sprayed the first landing that you see in that photo up at the top middle,
Okay.
and then every step on the way down, all the way to the floor of the foyer.
Did you get any luminescence on any step?
No.
Did you spray this wall over here? I don't know what to call that, to the right here in this direction.
Yeah, that would be, I would call that the west wall of that stairway.
Okay.
The process of spraying stairs, it's almost like using a spray gun, to paint a house or paint a car. The only areas that I would have sprayed on that wall would have been just lapping up as I went from stair to stair.
Okay.
Maybe anywhere from 2 to 3 feet above each step. But I didn't purposely spray that entire wall. One of the reasons it was a pretty white, bright white colored wall. And given the scenario of this particular crime scene, if there would have been any spots of blood, on that wall, in my opinion, it would have been fairly obvious even with the naked eye.
In other words, because it was a white wall and the specks of blood would have been pretty obvious and noticeable, correct?
That's right.
Now, the carpeting goes up to what's called the back door, is that correct?
Yes.
Did you luminol this whole foyer area, the carpeting area?
Yes.
And did you lap up to the wall itself, just like you did on the white wall?
Well, I did the whole carpeted area. I didn't move any of the furniture items that you see in that photo. But as far as lapping up the wall, I did, again, spray the entire wood surface, the vertical wood surface that was adjacent to those stairs.
What do you call that wall? East wall, west wall?
Well, it is east of the stairway. I think I called it in my notes the vertical wood paneled
Okay.
stairway wall.
Did you see any dripping blood on the porch area, or did you look at that area?
I didn't look in that area.
And to the best of your knowledge and ability, did you collect all of the evidence of evidentiary value at that scene that you processed between both of your visits that you made to that area?
Based on what I could observe, yes.
Were there items on the carpet that were of not evidentiary value, debris, threads, things of that nature?
Debris and,
Well, were there like threads and fibers and objects that were not of evidentiary value that were in that foyer area, if you know?
there could have been.
Okay. Now, I want to now focus on the fingernails of the decedent, Lana Clarkson. Part of your duties is to do a detailed examination of fingernail scrapings and things of that nature. Is that correct?
That's correct, for the purposes of finding biological fluids. That's
Okay. And were the fingernails of Lana Clarkson collected, or fingernail scrapings collected by a criminalist from the coroner's department to your knowledge?
Yes.
And did you later get that, those fingernail scrapings and items and subject them to some type of an analysis?
Yes.
Was the right thumb fingernail, was the entire nail actually extracted or taken off for later analysis?
A sample was received from the right thumb from the coroner's office. I took a swabbing, basically using a sterile, like a Q-tip swab, and putting sterile water on it. And I had swabbed the edges of what I had demonstrated or called in my notes, the clippings of the right thumb. That would have been like a moon shape type if you were just clipping your nails off. And also there was a larger apparent acrylic portion that I did not analyze. There was a smaller portion that also looked acrylic, so a total of 3 pieces that I did swab along with the clipping. And that's the areas that I swabbed as far as the right thumb clippings are concerned.
Okay, well, let me ask you sort of a general question when it comes to fingernail clippings and swabs. You're looking for trace evidence, is that correct?
Well, if it comes to the DNA section, our main focus is for any foreign biological material, be it skin material, possibly if somebody scratched somebody. That's the purpose as it comes to the DNA section.
Okay, and would you be looking for tissue?
Correct. That tissue, skin, same thing.
And
I think we're going way beyond what I indicated I wanted to hear from
okay,
you.
let's just,
Did he search the scene? And what did he find? And I have a couple of questions depending upon what counsel does, and that was it.
well, I'd like to at least ask about his testing of the right thumb.
No, you might like to, but I've indicated what I'm interested in, what is to me pertinent in this hearing.
May I make a brief offer of approval? Just
Yes,
for the record?
yes,
Thank
you may.
That he did the testing of the right thumb and basically got no DNA other than Lana Clarkson's DNA off of that nail.
If it becomes important, I'm sure we can stipulate to it, or the council can stipulate to it if it's not in question.
And he also did presumptive blood testing of the nail.
That's not what I want to hear about. I've indicated what I thought his relevancy was to this hearing.
That's my offer of proof.
Thank you for the offer of proof. The objection is sustained.
Thank you.
All right.
With that, I have no further questions.
People?
Just let me.
All right.
Your Honor, I don't think we have any inquiry at this point.
If any counsel can help me, can you, and I was looking through the transcript, but since I'm trying to listen to the testimony, it's difficult. Where Ms. Kaplan indicated she saw the object that Dr. Lee put in the vial.
My understanding of her testimony was that she said actually, no, Ms. Kaplan said she could not remember.
Okay.
It was Mr. Diamond who was specific. Ms. Kaplan said, I have no idea. She said that we were in someplace in the foyer area.
That's correct. It was Mr. Diamond who put it between the pedestal and I believe the number 4. Ms. Kaplan said she wasn't. So,
Okay.
Yeah, I believe she said she saw it on the carpet though, and it was about the size of the thumb.
I'm about to get there. We had a witness testify that she observed an object that was the size of a thumbnail. It was flat with irregular edges. This may be a question you can or cannot answer. Do you think you would have observed that in your examination?
Well, Your Honor, as you described it, I would have to say if it was just lying on the top of the carpet, that I would have observed that.
Could it have been somewhere else where you would not have? I mean, if it could be wedged somewhere that you might not have seen it.
That's possible, yes.
Okay, I have nothing further.
Yeah, would it be more likely that if it was a whitish object, you would have seen it given the nature of the carpet?
Again, if it was lying on the carpet, not wedged anywhere, behind a particular item, and if it was white, absolutely. I think that would have been an obvious observation and it would have been collected.
And okay, I have no further.
Okay, thank you. Anything further?
Just one question. You did not, I think you told us you did not move the pedestal or look underneath the pedestal. Is that correct?
Yes.
Thank you.
Thank you. Anything?
That's it.
So all right, if we're done with this witness, I think you can strap on your gun, jump in your Hummer, and go interrogate some suspects. Okay? All right.
See you soon.
All right. I mean, that is what you do, right?
We actually have an old pen in van and,
Oh, okay.
and no. It's flashlight.
I'm shocked. All right.
It is a day off. We can get about 2 minutes.
Yeah, I needed that at the end of a long week. I've got about 15 minutes before I have to go to my next hearing.
The only thing I would do is ask the court to take notice of one thing as an offer of proof. I think the defense has indicated that, I'm sorry, I'm about to use that, has indicated that Dr. Lee, in our requests.
Let's have some, yes, right. Okay, go ahead.
I'm sorry, Judge?
Go ahead. I'm sorry. There were some things, yes, there's some things I want to bring up as well.
Okay, Dr. Lee, according to the defense offer of proof about what Dr. Lee has or hasn't said, and keep in mind, we have not extensively interviewed Dr. Lee. He's not been available to us, notwithstanding requests by the people to do exactly that, to interview him. He's not been made available to us. My understanding of what Dr. Lee has said, based on the defense offer of proof, is he didn't find a nail. There was nothing nail-like that he found or recovered, that he found a white thread or fiber that somebody must have mistaken for a nail. Somebody must have mistaken for a white object. Somebody must have mistaken for this thing that kind of was hanging around out there that the people kept seeking evidence about. So when that was made available to us, we turned around and said, well, then give us the thread, this white thread that could have been mistaken for a nail.
I'm going to object. That's not what Dr. Lee is saying.
Wait a second. You'll have a chance to respond. He's making a motion or making a request to the court, or he's done. You're going to get a chance to respond.
Yeah, and that's my understanding is just a second ago, Mr. Plord stood up and said it was a white thread or white fiber, unless I misunderstood it. And that offer of proof came from Dr. Lee. We then made several requests about what that thread is. Give us the thread then. We received a packet with 2 items of purported evidence in it. One, they were both in Post-it notes. One was supposedly a blood stain that was recovered literally in a Post-it note.
And you're putting this up on the screen.
I am, and I should go ahead and mark this as a
Next in order would be 20.
I'll place a court's 20 on the back. Although the numbers you'll see, Your Honor, are a mirror image, that's just because it was put on a scanner, and that's a mirror image of what we're looking at. The original photograph, obviously, is the correct way. So that's one of the items. And the white thread-like object is that. So that's what we received from Dr. Lee, and at this point, we've received nothing else. And
We're going to mark the show.
Yes, that should be 21.
So the claim from the defense that we received from Dr. Lee, the 2 items of evidence that he recovered at the scene, that's these 2 items, unless I'm mistaken about something, and it can be cleared up right now. And these are the 2 photographs that I submitted to Mr. Ford. These are our photographs I submitted to Mr. Ford after we received these items from Dr. Lee.
Ms. Clark?
These are pictures of the way these items are now. There were recent photographs of them. Dr. Lee photographed them at the time he collected them. He will testify about his photographs and what he collected, how it was packaged, get a picture of the packaging and so forth. And Dr. Lee, I believe in his notes, said that these threads were bloodstained. In other words, they may have been white, but they have blood on them and so forth. And I believe they were collected around the area where this pool of blood was. I don't want to speak for Dr. Lee, that's my understanding. And then the blood stain was on the stairs, one of the stairs. I can't remember which one it was, but it's in his notes that he did a Kastle-Meyer test and collected that item and packaged it, and that's one of the 2. And it looks like it's broken up now. It looked like it was all together when Dr. Lee collected, because we have a picture on the photograph, and I'm surmising it was scraped up and then it's kind of busted apart. Dr. Lee specifically has said he did not collect any nail material or nail-like material. and those are the only 2 items that he collected. He did make other observations of items that he noted at the scene, but he puts in his notes, saw this but did not collect. In other words, there's things that he may have looked at that he didn't collect, or, I would assume, and I'm just surmising, the same as this criminalist, there's certain things he may have looked at that didn't turn out to him to have evidentiary value. For example, he looked at this blood pool. He said he didn't see any reason to collect anything from that other than the fibers that were identified in his notes. Dr. Lee's not trying to say that Ms. Kaplan is or is not.
Well, we're from Dr. Lee.
Right.
It's real simple because right now your description, I'm not saying there's a long ways to go and I have to wait till I hear everything, but what I've just seen, and I understand it may have been, tested or whatever, but the items that were contained in courts 20 and 21 are not consistent with what Ms. Kaplan testified to.
Correct.
She testified to a flat object, the size of a nail with irregular edges. That's not what I saw.
I agree, and I don't know what the discrepancy is. I do know that Dr. Lee will testify that he collected these 2 items and only these 2 items.
All right. Well,
And I do not know with reference to Mr. White, and I see 3 separate events here. You have the diamond issue, the tooth.
Yes.
That's separate than the White issue, I think.
yes, maybe.
And then you have the Sarah Kaplan issue. I see 3 separate.
Quite possibly, there are 3 independent, separate issues.
Right. Now,
That's
I
correct.
think the evidence will bear out that the White issue is really this blood that's a clump of blood, and we think maybe some tissue, meaning human tissue, all kind of clumped in together. I'm not certain of that, but that's my view of the evidence. And then, but we'll wait to hear from Dr. Lee and the analysis of that material. It's being looked at by the sheriff, and we want to look at it because we've never tested it. We've never looked at it. We'd like to test it to see if it's Lana Clarkson's blood, et cetera. And the court has Dr. Lee's notes. It's in the motion materials.
All right.
From the scene, and they document what Dr. Lee did at the scene as far as what he looked at, what he collected, and I believe the only thing I asked Dr. Lee, do you remember anything other than your notes and your photographs? No. Did you collect anything other than he always documents it in his notes? That's what these.
Well, let's wait and see till he comes in. In the meantime, the people, we had talked about some orders, Ray Discovery and Dr. Lee. Specifically, what do you want me to order?
Your Honor, I would ask that the court order immediately that Dr. Lee's original notes, the original documents on which he wrote his crime scene notes, to be made available to the people. I assume, I'm just guessing, but I'm assuming they may be in Connecticut. Even if Dr. Lee is out of town, those notes could be compiled. I have a copy of them.
Well, I'm not so sure I would order that without Dr. Lee approving and sending them. He has a right to his work product to be sent to me, but to say, you're not there, let somebody else gather it.
I have no problem if the court orders that those original notes be sent to the court. I'm not trying to.
What I'm saying is, even in the gathering, I think if he's out of the country, if I were a doctor and I have notes and a court ordered me, I'd say, fine, I'm going to comply, of course, but I'm not there as soon as I get there, as long as it was within a reasonable time.
Okay.
I'll have those forwarded to you.
Then I guess that brings me to my next point, which is I would ask the court to order the defense, as much as this court has indicated that its powers are not unlimited, which was news to me.
It's the first thing. It's the first sad discovery you make as a judge.
Well, that having been
The
said,
second is your paycheck. Right.
whatever either order the court could levy, or maybe just an accommodation for the defense, and we all get along, and I would ask the defense just as an accommodation to see if maybe they could get a hold of Dr. Lee, and if the court could extend an order that the defense try to make Dr. Lee available at the soonest possible time. The wheels of justice are still spinning, and we're starting with evidence on Monday. Obviously, we would like to get this issue resolved. So that's the second order, in as much as the court can do.
I think what I can do is make a request, and I'm going to request the defense that if you can contact Dr. Lee, we want to get his original notes. We want to arrange his testimony at the earliest possible time. And even if we have to, if he's coming in on a day when we have jurors in, if we have to, dismiss the jury for a period of time, it probably would be worthwhile.
And before you speak to that, Mr. Plourde, I have a third. This probably goes along the same lines, I'm assuming, as the original notes. Dr. Lee, I think I mentioned this morning, supplied us with 55 photographs. I suspect, based on my review of those photographs in digital form, that some of those at least were negatives, or 35 millimeter. I would ask for the negatives If any of them were digital, I would ask for the original format to be made available to us. Obviously, non-destructive, we're not going to do anything destructive to any of them, but we need to see the originals.
Okay, does anybody wish to be heard?
Yeah, briefly, Ms. Kenny and I are, we, you know, Dr. Lee, we've already made inquiries to try to get it in here as soon as practical when he gets back. And one of the questions that we were going to ask today is whether or not we limit it to Fridays.
No.
And okay, that's good because we were going to have problems. We talked to one of his assistants and we got a hold of his schedule and we're going to try to do that. So based upon the court's representations, we will try to get him here as soon as practical, whether it's a Friday or not. And then my only hope is that we can get him, once we get him here, we can have him testify, get him done, and then get him on his way to wherever he's going to go.
The only proviso I would make, the one day I'm not going to be available is the 17th of May. We're going to be dark that day.
Okay.
So any other day besides that.
Okay. Next Tuesday.
Thursday.
Well, too, but we're available.
We're available.
Yeah, what-
He's not here anymore.
Well, I'm going to talk about next Tuesday because we know that a juror has a pre-existing appointment, but we have time and we have other discovery issues to face. And I'd like to deal with the rest of the people's motion or the thrust of the people's motion, which is this failure to turn over various materials outside of the ones we're talking about and, you know, potential sanctions or exclusions. I'd like to take that up on Tuesday since we're going to have a day free.
Okay, and then with regard to the request regarding notes, photographs, et cetera, negatives, our position, and we were being very cooperative. I was trying to cooperate with the DA that was handling discovery, and I'm trying to give him stuff as we get it, because there's a lot of stuff that's coming in as we speak, and the other DA is trying to do the same. Things are kind of going back and forth. There were some things that were missed that we're, you know, catching up on, et cetera. Was a request for the original notes, and we were talking about go back and look at Dr. Lee's notes in Connecticut. I told him that, you know, legally, unless ordered by the court, we're not obligated to give him the original notes, and I don't know whether Dr. Lee would have a problem turning over his original work product or not. The same with the negatives and so forth. Then they filed the discovery motion or asking to impose sanctions and so forth for other alleged violations. So my position is very clear and with the court that we will comply as best we can with the discovery statutes and any order the court makes.
Okay.
And we'll leave it at that.
All right, here, I can help you. Without making any final decision, without getting into a lengthy discussion, I've done a lot of research. There are very few, if any, published cases concerning photographs of expert witnesses from the defense. However, and I realize unpublished cases cannot be cited, but there are more than a few that have indicated, including a couple from this district, not that that makes a difference, only, in fact, it makes no difference whatsoever. But the bottom line is that if an expert relies on photographs, is planning to use photographs, well, if they're going to use the photographs, clearly they're discoverable.
We agree.
By analogy, there are certainly cases published and otherwise that would indicate if an expert is using any item to form an opinion, to testify, that those are discoverable. And if as far as production is concerned, whether they're admissible at the time in front of the jury is another story. I'm going to order that Dr. Lee produce his original notes, his original photographic material, or whatever the medium was. And when he comes to court, he's to bring those with him. And we'll worry about it at that time, but he's to have them in his possession.
Yeah, typically he does, Your Honor. I'm not quarreling with that. This was making them available to them, sending them to them.
I'll make that decision. I think the best way to do it is bring it in. We'll have a discussion. We'll argue it as appropriate. I'll make a ruling, whatever it is, and then we'll decide how to do it from there.
Very good. And I would indicate to the court that one of Mr. Lee's assistants at his direction did give him digital copies of all the photographs.
They're saying they're having a problem with the copies. The bottom line is, it doesn't hurt, unless you show me otherwise, bring the originals with you, and I'll work on it from there.
That's fine.
Okay?
That's what.
So we'll plan on working next Tuesday, even though the jury won't be here, and for the discovery issues. And you have my request concerning the other issues, and I'll see you 9:30 on Monday morning.
Thank you, Your Honor.
We have another witness, also Dr. Carroll.
Today?
No, for Tuesday.
Bring Dr. Harold in.
Thank you.
We're going to be here. We have a whole day.
That's what we plan.
Okay.
I used to love Dr. Lee. He was on the Forensic Files all the time, just about every episode. Seemed like it. I don't know if I ever saw his TV show. I probably did. But I didn't know. I used to love him, but I didn't know that he had been part of the O.J. Simpson trial. And then when I found out that he had been, I was like, wait a minute. He testified for O.J. Simpson? And then I kind of lost a little bit of respect for him. And now I'm finding out things like this. That's not good. So I think that's the last of this hearing. Because I think now we're back in the presence of the jury. So the next witness is Sergeant Chris Russ, and it is an hour and 14 minutes long. Do you guys want to do another hour and 14 minutes? Or do you want to quit now? But that's all we can do is another hour and 14 minutes. Because I got to rest before I take the little idiots to the vet. Because I'm going to have a fight on my hands. Because they do not like to go to the vet. Because we have two vehicles. I have a Mustang. Travis has an F-150. They know if we're going somewhere in the Mustang, they know it's to the vet. Because that's the only time they ride in the Mustang is to the vet. So if I try to put them in there, they know where they're going and they fight me. And one time not too long ago, I've had a bad back for forever. I've had back surgery before, but maybe a year ago, year and a half ago, I was getting Spike in the car. And I don't know what he did, but I hurt my back bad to the point that I screamed. And then I couldn't walk. And his halter slipped off of him. So I couldn't walk. I couldn't move. I was just standing there screaming. He's running all over the yard. His halter's on the ground. I had to call Travis to come home from work because I had a vet appointment. So I'm like, you're going to have to come home and help me get him in the car. I didn't say anything about the halter. So he comes home and he's like, where's his halter? He slipped out of it. That's why I can't get him in the car. That's why I called you. They hate the vet. Absolutely hate them. Just to get their nails cut. That's all they're doing is getting their nails cut. They still hate it. I told Belle, I said, you can pee on them if you want to. Don't tell them I said that, but you can pee on them. Because she does every time. She pees on them every time. So who's up for some more Phil Spector? If not, we can be done. I don't care. Yes, no, maybe. I'm going to take that as a yes. Quit defending them, Judy. They're little terrors. Come on, StreamYard. That's court TV, I guess. Why is it buffering? Come on, court TV. Why is your thing not working?
This court is now in session. General Larry Paul Filler, judge presiding.
All right, the record will reflect defendant is present with his counsel, including Mr. Cutler. You feeling better?
Thank you.
You're ordered to stay well.
Thank you.
District attorney is present, the jurors and the alternates are not present. We have some matters to deal with briefly.
Good gravy, Marie. What is wrong with it? This is Court TV's website now. This isn't even. I want to do the original corn rate trial. I was going to wait until after Karen Reed, but let me take a look at it. Wait, if we have time to do it before Karen Reed,
are not present. We have some matters to deal with briefly before we proceed with testimony. One would be on Friday night, I received a communication from our public information officer who had been contacted by counsel for the Los Angeles Times, and then I was faxed the letter that they were trying to fax me, and they couldn't get to me before I left on Friday, indicating that a freelance writer for the Times had made contact, albeit apparently telephonic and email contact, with juror number 6. They had a pre-existing, when I say relationship, I mean just a business relationship. She's an entertainment writer who freelances, and he is in the entertainment business, as we all know. And she was making an inquiry concerning whether jury service would impact his company's business. Now, the Times, through counsel, became concerned because obviously this was contact with a juror, and they indicate that when they became aware of this exchange of information, they told the freelancer not to communicate further with the juror. I had a conference call then, which I arranged through the district attorney's office, between Mr. Dixon, Mr. Jackson, and Mr. Rosen. And Mr. Rosen was aware of this. He had apparently given a copy of the letter, and our only concern is to find out indeed if it impacted the trial at all. It didn't appear that it had. It appears to be what it shouldn't have happened. It doesn't appear to have had a major impact. I did receive this note because the juror informed us what had happened, and I'll read you his letter, and then I'm going to bring him out and just make sure that he feels he can continue to be fair and impartial concerning this matter. From juror number 6, contact with entertainment journalist from the LA Times calendar section related to the trial. The journalist is someone I have ongoing contact with, so a dialogue is common. However, she asked if my jury service would conflict with my ability to function at work, supporting our summer movie releases, close paren. I did not respond to her inquiry related to jury service by email. I left a voicemail informing her that my job will not be impacted and that we have significant programs in place to support our releases. He did include what the releases are. I don't see any reason to give them free publicity. They don't need it. Naming the 2 movies, I guess, that he's working on. So what I propose to do, unless somebody has an objection, is to bring juror number 6 out, simply ask him if anything else happened other than what appears in his letter to me, which I have just read to you, because there's nothing inconsistent with that and what the letter from the Times counsel to me, which you all have. So unless somebody else has some other concern, if you want to ask any questions, you may, and I'm hopeful that we can then move along. I was also, and I want to check, one of the jurors had some concerns that I guess when he was outside, either going to their parking place or whatnot, that he noticed a juror, somebody with a long photo lens taking pictures of him, or he believed it. And I want to find out a little more about that and to make sure if it's happening, it better not. It's real simple. Mr. Rosen?
Do we want to flick off the cameras for this one?
No, he's in the jury box. You can't see him.
Well, I'm thinking about the answers.
I'm sorry?
I'm thinking about the answers
In what way?
in terms of,
Not if we voice our questions accordingly. It shouldn't be a problem.
I think you're in control of the questions this morning.
Well, I'm not going to stop you from making an inquiry, but I think a little common sense goes a long way, as it normally does. And you have lots of that.
We certainly don't want to pierce that wall of anonymity.
I don't think that's going to be a problem.
Okay.
He's one of the 2 jurors that is most likely, and he recognizes it, that people may well know who he is. And only the mainstream media has been they may not agree with my decision, but they certainly have respected it, which is all that I ask. Not that they agree, just that they understand what we're doing and why. And the reasons that we have an anonymous jury is so that we can pick a good jury, so that we can get a true cross-section of people who are not concerned about having their anonymity pierced, that they are able to go on their lives and with their lives without having people annoy them. And that protects primarily the defendant's right to a fair trial, which is why I did it. Okay? And which the law allows me to do. Now, let's bring out juror number 6, if you will. I hope this will be very brief. I have read your letter. Does that pretty well summarize why don't you summarize for me exactly what has happened as the Times has contacted me, it's been reported in the Times in your letter to me.
Yes. The journalist who contacted me is someone who I have a professional relationship with and also have social interaction with on a ongoing basis.
When you say, does that mean a dating relationship or just?
No. Professional and social within professional.
Okay.
When I was impaneled on the jury, the journalist had contacted my corporate communications office asking if, trying to find out who was impaneled, because this is someone that I have an ongoing relationship with. I had left a voicemail saying that I was impaneled, and I look forward to talking to her after everything's done. I received an email, I think around March 20-something, about technology, 3D technology, theatrical distribution, which is kind of stuff we normally talk about, to which I responded back to. And then I heard back from her on May 2nd. If I thought that it would warrant a book, I responded back. And then she sent a separate email asking about the jury service, if it would impact my ability to be able to function in supporting our summer releases.
There's something in the book that went by me, I'd like to go back. What would support a book?
She said, well, the question was about 3D technology and theatrical distribution. And then a week later or so, she said, do you think there's a book in this?
You're talking about the technology as opposed to your jury service?
Yes.
Okay, thank you. That's all I wanted to know.
Yep.
Okay.
And then when she asked about the jury service impacting my job, I did not respond back. I left a voicemail saying the jury service would absolutely not impact my ability to get my job done, and that I work, of course, ridiculous hours, blah, blah, blah. That's it.
Is there anything about this contact that in any way concerns you as to whether you can be a fair and impartial juror towards both sides in this case?
No, sir.
All right. Does any counsel wish to do any further inquiry?
I just have a couple of questions.
All right.
Good morning. Was there any approach, verbally or through writing, from this? I understand it's a freelance writer, is that this young lady?
I thought you worked there, but yes, I guess.
Was there any, either email or any other way, ask you about what you were doing in the trial?
Not about what I'm doing in the trial.
And was there any questions at all about anything to do with the trial?
Well, it related to if the jury service would impact my ability to do my job.
Okay. Other than that?
No.
That was the only subject which touched it. That was a terrible question. Let me rephrase it. That was the only question that touched on your jury service.
Yes, she made a humorous comment as well.
Okay. Is it one that we can share in open court, or you prefer not to?
I can certainly share it with you. I mean, I don't remember. Here's the thing: I don't have a committed memory. I think she
the gist of it.
It'd probably be best if I gave you the email.
I'm sorry.
It would probably be best if I gave you guys.
If you want to file the emails with us, you may.
Yeah,
You can just bring it with
otherwise,
you.
I'm going to paraphrase something there.
All right, bring it with us, and we'll put it in an envelope, and I'll share it with everyone.
Just one last question. Is there anything about this contact with this young lady that in any way would bear upon your service here in this case?
No, sir.
Thank you so much. All right, anything further? People?
No, thank you, Your Honor, nothing further.
All right, let's bring out the rest of the jurors then. Thank you. Thank you, sir. All right, the record will now reflect that all of our jurors and alternates are present, and good morning and welcome back, ladies and gentlemen. Just before we resume with testimony, something's been brought to my attention, and it may be very minor, it may be nothing, it may be something, and I want to see if any of the other jurors, if it's happened to them. Juror number 7, I understand that you believe that when you were pulling out of where we have you parking, that you saw somebody with a long lens attempting to take a picture of you?
Well, when as I was just pulling out, I was just looking for traffic, and when I glanced across the street towards the courthouse, because that's the direction I need to look at, I just saw this black round thing pointing at the direction of the exit or the entrance to the parking lot. And
you remember when this was?
It was last Monday.
Last Monday, okay.
About, it was at 10 o'clock or so.
All right.
And I said, no, what that is? And I said, it's like a camera glass. So I just kind of glanced away because I was looking for the pedestrians.
Okay.
And then I glanced back again, and then some cars came, and I couldn't get out. It was kind of jammed up. And then I saw a person walk in front of the camera with a white jacket and I think it was a woman. It might have been a skirt or pants, I don't remember. And then as the traffic moved, and the person moved away from the camera again, and then I looked and the camera's back in view of myself. And I just it's something I know.
It's good for you to bring this to our attention. Any other jurors notice that? Anybody? Okay, thank you very
And I
much.
was on Broad, I was on Broad.
No more information. Because I'm aware of where you're parking and whatnot. It may be totally innocuous, and at this point, I have no other information. I would just say that anyone that wishes to in any way violate this jury's anonymity or in any way tamper with this jury, I look forward to the day that you're in my courtroom. With that said, are we ready to proceed?
Yes, we are.
All right.
Officer Chris Russ.
Please raise your right hand to be sworn. Do you solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please be seated. Please state and spell your first and last name for the record.
Chris Russ, CHRISRUSS.
Thank you. You may proceed.
Thank you, Your Honor. Good morning, officer. What's your occupation and assignment right now?
I'm a sergeant assigned to the Professional Standards Unit of the Pasadena Police Department.
How long have you worked with the Pasadena Police Department?
A little over 12 years.
I'd like to invite your attention to July 3rd, 1993. You were employed by the Pasadena Police Department on that day?
Yes, I was.
As of that day, how long have you been with Pasadena PD?
Approximately 6 months.
Had you worked as a peace officer prior to joining the Pasadena Police Department?
Yes, I did.
Explain that briefly.
I worked for the Lincoln Police Department in Northern California.
11 years?
Yes.
So even though you've just been with Pasadena Police Department for 6 months, in July of 1993, you had over 11 years of police experience, correct?
That's correct.
Now, on that day at about 5 o'clock in the morning, were you actually working?
Yes, I was.
So in July 3rd, 1993, you were working. What was your capacity? What was your job that day?
I was assigned to patrol with a partner, routine patrol services.
So you were in a black and white vehicle?
Yes, I was.
In uniform?
Yes.
In your partner's name?
Max Dahlstein.
On that day, about 5:15 in the morning, did you receive a call to do something?
Yes, I did.
What was it?
We were assigned to respond to an address in Pasadena regarding a possible robbery call.
Was that 1210 South Arroyo in Pasadena?
Yes, it was.
And after receiving the call, did you go to that location?
Yes.
Your Honor, could we have people one up on the board?
All right.
Thank you. Officer, I'd like to invite your attention to people's one for identification. There are two people shown in that photograph. For the purpose of this question, do you recognize the woman as a person that you met on July 3rd, 1993 at about 5:15 in the morning?
Yes, I do.
Dorothy Melvin?
That's correct.
14 years ago, correct? 14 years ago. To the best of your recollection, where did you first meet Dorothy Melvin?
I believe it was on the roadway in front of the house or just a short distance from the home.
When you say the house, do you mean the address 1210 South Arroyo?
Yes, I do.
Now, was she a pedestrian in the street? Was she in a car? What was she doing?
She was next to a car that was parked on the roadway.
And did you have a short conversation with her?
Yes.
What did she say?
She said that she was at her boyfriend's home, the Phil Spector, and that he displayed a handgun for her license and also
back, correct?
That's correct.
Did she make any request to you with respect to the handbag?
Yes, she wanted us to go to the residence and recover her handbag.
Now, as of that day, July 3rd, 1993, when Dorothy Melvin said, "My boyfriend, Phil Spector," did that name have any significance to you at all?
No.
Had you ever heard that name before?
No.
After Dorothy Melvin told you what you've just told us, what did you do next?
We went to the residence and contacted Phil Spector.
How far away from where you met Dorothy Melvin was the home where you found Phil Spector?
To the best of my recollection, just a short distance.
Did you actually have a face-to-face conversation with him at that location?
Yep.
Again, inviting your attention to people's, one, for identification. Do you see the person that you met, that you learned to be Phil Spector on that date in 1993 in the photograph?
Yes, that appears to be him.
Did you see him here in court?
Yes, I do.
With the pink shirt?
That's correct.
Indicating the defendant for.
Thank you, Your Honor. So after you talked with Dorothy Melvin, you went to the address at 1210 South Arroyo, met Phil Spector. What happened next?
We explained to him why we were there and asked permission to go inside the home and search for the purse.
Did he have any response to you with regard to this request?
He led us into the home and allowed us to look for the purse.
Did he talk to you about who he was?
Yes, he told us his name.
It's 1220, Your Honor.
The objection's overruled.
Thank you very much. Please tell us.
He told us who he was and made a point to show us some of the artifacts in his home. One that I recall was a guitar, I believe, that he said was given to him by John Lennon.
Now, this is the first time, as you told us, that you met Phil Spector. But having that in mind, when you first talked to him, he told you about the guitar and the like. Was he pleasant and courteous or upset and angry?
He was pleasant.
You mentioned him, asked him for the handbag. What was his response? Come in and look?
I don't recall exactly what his response was, but he did allow us to the home.
Did you find the handbag immediately?
No, we didn't.
Now, when you say we, you mean and your partner, correct?
That's correct.
After you did this, was it a quick or extensive search for the handbag?
A pretty casual, quick search for the handbag.
And after not finding the handbag, what did you do next?
We left the residence and recontacted Dorothy Melvin.
Was she still in the same place? To the best of your recollection that you left her when you went to Spector's house?
I don't recall for sure.
When you say you don't recall, you aren't sure whether she was there or perhaps at the police station?
That's correct.
Okay. A long time ago.
Yes.
You returned to Dorothy Melvin in one place or another. Did you tell her the results of your search at Phil Spector's house?
Yes, we did.
And what was her response, if any?
Overruled. Ladies and gentlemen, this will be limited to explaining what, if anything, this and any other police officer did in response to what she said. It's not received for the truth of the matter asserted. You may proceed.
Thank you, Your Honor. You can answer the question.
She responded to information we provided her. Phil Spector had told us that if Dorothy came to the house, that he would return the purse. At that point, we asked her if she was willing to go back to the residence, and then we accompanied her to the home.
So you went to Phil Spector's house, didn't find the handbag, went back to Dorothy Melvin, and then all three of you went?
Overruled. This helps put it in context. Overruled.
All three of you went back to Phil Spector's house on Arroyo Parkway. Arroyo Drive, I'm sorry.
Arroyo Boulevard, yes.
Yes. When you all arrived, all three of you, what happened then? Tell us.
My partner and I contacted Mr. Spector, I believe it was at the front door or a side door. At that point, initially he was cooperative, and I'm not sure of the circumstances, but for some reason he became upset and demanded that we leave.
At that point, well, let me withdraw that and ask you this. You told us earlier that Dorothy Melvin mentioned that there was a handgun involved.
Yes.
Correct. At that point, did you see a handgun?
No, I didn't.
Did you see any evidence or indication of a handgun?
Not at that point.
Later on, did you?
I saw a shoulder holster that was worn by Mr. Spector.
And could you describe that for us?
As best as I can recall, I believe it was for a small handgun, and I believe it was brown in color.
Now, did that mean anything to you with respect to officer safety? An empty shoulder holster but no gun. Did you think there might be a gun somewhere?
Yes, I did.
And what, if anything, did you do with respect to that? Were you cautious?
Yes, this was shortly after a supervisor was requested to come to the scene. We detained Mr. Spector. I don't recall if I saw the shoulder holster before or after we detained him. He was placed in handcuffs.
All right, but we got a little ahead of ourselves. So you came back with Dorothy Melvin to his house, Phil Spector's house. He became upset at some point and asked you to leave.
Correct.
What did you do then? Did you leave?
No, we requested a supervisor.
And that would have been what, a sergeant?
Yes.
And why did you do that? Why did you ask for a sergeant?
Objection.
Overruled.
We requested a sergeant because the nature of the call, possibly we might make an arrest for a robbery, the fact that he was uncooperative and demanding us to leave the residence.
And that's what you're supposed to do according to your policies, correct?
According to standard practice, yes.
At some point, after you made that request, I guess over the radio, is that right?
Most likely, yes.
Did a sergeant from your department arrive at Phil Spector's house?
Yes.
Was there a brief discussion with the sergeant filling them in?
One of us, either my partner or I, would have briefed our sergeant about the circumstances.
Now there are four of you. You and your partner, the sergeant, and Dorothy Melvin, correct?
Correct.
What happened next?
At that point, we detained Mr. Spector, placed him in handcuffs, and I believe that's when I saw the shoulder holster.
Now, you said at some point he became upset. Was that before you called this sergeant?
Yes, it was.
Describe to us how he was upset, because earlier you said when you first contacted him, he was polite and courteous.
I don't recall exactly. I know that the report that I wrote says that he was irate and uncooperative, and I can't really describe what his actions were at this point.
And in fact, let me ask you a couple of questions about that. Your last answer. You wrote a report about this.
Yes, I did.
What, 2-3 pages?
I believe it's 4 pages total.
And where you outlined, to the best of your recollection back then, what happened.
Yes, I did.
And the report would have contained Phil Spector, Dorothy Melvin's names, right?
That's correct.
And where it occurred?
Yes.
And the request for the handbag?
Yes.
Okay. So, to the best of your recollection, Phil Spector was upset. He was handcuffed and detained. Correct, right? What did you do next? Were you still looking for the handbag?
My partner looked around the residence for the handbag.
And what happened? What was the result of that search?
He found the person in the living room.
And after apparently he found the handbag, did he come back to where you were?
I believe so.
And you saw it?
I can't recall if I saw the person on.
At some point, did you see Dorothy Melvin with the handbag?
Yes, I did.
And where was she when your partner gave it to her?
I don't recall if we were in the yard or out near her car.
Somewhere near the Phil Spector residence?
Yes, that's correct.
And did she appear to recognize the handbag and indicate to you that it was hers?
Yes, she did.
Now, we earlier talked about the shoulder holster and the fact that you did not see a handgun. Did you ever see any kind of weapon while you were at Spector's house?
Yes, I did.
What kind of weapon?
It was a shotgun.
When did you see it?
Sometime just before we left the residence.
After your supervisor arrived?
That's correct.
The sergeant?
That's correct.
And before or after, or do you recall in relationship to finding the shotgun? Okay, let me withdraw and ask you again. You said you found the shotgun. Do you recall whether or not you found that before or after the handbag was located?
I don't recall.
Okay. All right. Describe the shotgun for us.
The best I can remember, it was a pump shotgun. I believe it had a brown ribbed forend, and that's all I can remember.
Did you actually find it?
I don't recall if I did or not.
But you saw it there?
That's correct.
In his house?
Yes.
And this was after you noticed the shoulder holster?
Correct.
So you were a little bit on alert for guns?
That's correct.
And that would have been for your safety and the safety of your fellow officers?
Questions are really getting leading and suggest. Sustained.
Why were you concerned about any weapons, shotgun or handgun?
We were actually looking for the handgun, and I believe that's when the shotgun was found.
Now, after the handbag was found and returned to Dorothy Melvin, was there a conversation with her regarding whether or not this was going to be pursued more? Whether a report or charges were going to be pursued?
Yes.
And where did that occur?
I believe it occurred near her vehicle.
And did you participate in that conversation?
I don't recall if I was directly involved or nearby.
But you heard it. You were within earshot, correct?
That's correct.
Okay. And what did she say and what was said to her, if you recall?
I remember her telling us that she didn't want to pursue formal charges against Mr. Spector because of her status, her employment status, and Mr. Spector's position within the, I believe it was the music industry.
Did she, what you mentioned in your last answer, her employment status, did she elaborate on that?
Yes, she said she was the manager of Joan Rivers.
And at that time, did you know who Joan Rivers was?
Yes, I did.
Because earlier you said that you didn't recall who Spector was when you first went to this incident.
That's correct.
Who was Joan Rivers and why did that catch your attention? Overruled.
She was on television. I believe she had a talk show that was on syndicated television at the time.
Now, going back to the first of our questions and my questions and your answers, you said that you were on patrol at this time. That was your assignment.
Yes.
How long did you work on a patrol during this period? Year, 2 years, 5 years?
With Pasadena Police Department?
Yes.
The entire time since I was hired. So approximately 6 months.
So I would imagine during that period of time, you would get many domestic disturbance type calls. Is that right?
Objection, relevancy.
Sustain.
Is there any reason that you particularly remember this incident?
Overruled.
Because of the status of Dorothy Melvin claiming that she was Joan Rivers' manager, the fact that Mr. Spector had shown us a guitar that he had received from John Lennon.
So that stood out in your memory even today.
That's correct.
Before, let me withdraw that and ask it this way. After the handbag was returned to Dorothy Melvin, do you recall her ever making any indication towards her head with respect to you or any of the other officers?
I remember her parting her hair on one side and leaning forward with her head.
And did she do that with respect to you or one of the other officers, or do you recall?
I don't recall.
Could I have a moment, please?
You may.
Thank you, Your Honor. Nothing further at this time.
Thank you. Defense?
Thank you.
Good morning, Officer Russ.
Good morning.
My name is Mr. Rosen. I'm going to ask you some questions here this morning, okay?
Okay.
If I ask a question and it's inarticulately put, you let me know and I'll rephrase, okay? As I understand it, as you sit here today, you have been working for law enforcement for 23 years combined, is that correct?
A little over 20 years, yes.
You're a veteran, correct?
I've been in the business for a little while.
Couple of decades and a half, huh? Okay. You started, you said, with the Lincoln Police Department, is that right?
That's correct.
I'm thinking Lincoln, Nebraska. I may be wrong about that, am I?
Lincoln, California,
Okay.
northern part of the state.
And you were with them for 11 years, is that correct?
That's correct.
And then you came to Pasadena, and in 93, I think you told Mr. Dixon you had been with Pasadena approximately 6 months, is that right?
That's correct.
And you are still with Pasadena today, is that correct?
Yes, I am.
And today your title is Sergeant, correct?
Correct.
Let me ask you a little bit of your background and your history. Before you became a police officer, you attended an academy, didn't you?
Yes, I did.
Okay. It's required for all recruits, isn't that right?
Yes.
And in that academy, you take and you learn various disciplines. Isn't that a fair statement?
Yes.
One of the courses you take is you take a report writing class. Isn't that correct?
That's correct.
And that's a formal class, correct?
Yes.
Number of hours that you have to complete to the satisfaction of the department in order to pass, right?
That's correct.
And they teach you various things in this report writing class, don't they?
Yes, they do.
Let's take a moment and visit that. It's a number of hours, isn't it? 10, 15, 20 hours, something like that?
I don't recall.
Okay. A little while ago?
It's been a while, yes.
Okay. In that, they teach you how to fill out a report, how to write a report, because of course a police report ultimately becomes an official business record. Isn't that true?
That's correct.
And in the training that you receive, you are taught, as I understand it, to, when you write these reports, to be accurate, correct?
That's correct.
To be truthful, correct?
That's correct.
To be honest with what you were either told, saw, observed with your senses, correct?
That's correct.
You are also taught and trained to include all things of importance in terms of that particular instance or investigation at that moment, correct?
That's correct.
And you are taught to include things whether they are incriminatory or they are exculpatory. Isn't that correct?
Yes.
In other words, if they point to criminality or if they don't point to criminality. That's a fair statement, isn't it?
Yes, it is.
You learned that in the academy, and you took that knowledge and that information with you into your profession as a law enforcement officer, correct?
That's correct.
And I assume there's just absolutely no way you could even begin to estimate how many reports, official police reports, you have authored yourself or participated and helped in authoring over 23 years in this profession. Is that fair?
That's fair, yes.
In the thousands, probably. Isn't that correct?
Most likely, yes.
And I would presume further and assume further that, like most of your colleagues and your brethren, once you write this report, you check it over carefully before you file it, correct?
That's correct.
And the reason you do that is you want to make sure that when you file a police report as an official business document, that it's accurate, true, and correct. Right?
That's correct.
Okay. And that has always been your practice as a law enforcement officer, correct?
Yes.
And certainly that was your practice in 1993 when you joined the Pasadena Police Department, right?
That's correct.
You certainly didn't leave your skills and experience behind you when you came there, did you?
No.
Okay. And in July of 93, that was your practice, correct?
That's correct.
And in fact, on July 3rd of 93, that was your practice, is that right?
That's right.
Okay. Your Honor, Foundation, may I approach to establish that's in fact it's the report? Thank you.
Let me ask you, do you intend to ask questions about this?
Yes, I do, and I'll return to the podium. All right. But I just want to establish the foundation. Officer Russ, I want to hand you the report at this time that I have. And I want you to look at it over carefully and make sure that in fact this is the report that you authored on July 3rd of 1993. Your Honor, may I remain here while he's looking at it?
Yes.
That's correct.
This is it?
Yes.
And in fact, at the bottom left-hand corner of the face page, I see printing that says C. Russ, and unfortunately my copy's not very good, but it looks like badge number, I can't make out the first digit, but it looks like 26 something. Is that correct?
It's 8269.
8269.
Correct.
Okay. And this is the report that you authored, is that correct?
Yes, it is.
And the contents of this report reflect, as I understand it, the incident that you participated in and witnessed that Mr. Dixon just asked you extensively about a moment ago, correct?
Yes, it is.
Now, as I understand from your testimony, you indicated that you responded because I think you said that it was a possible 211. Is that right?
That's right.
All right. Let's define what a 211 means for those of us who do not work in the area like you and I do all the time. A 211 is a what?
It's robbery.
It's a penal code section, correct?
That's correct.
And it is the penal code section that defines robbery, right?
Yes, sir.
Okay. And you thought preliminarily it was a possible 211 because of what Miss Melvin had told you regarding the taking, the unlawful taking of her purse, correct?
That's correct.
The same purse that ultimately was returned to her by Officer Dahlstrom, right?
Yes.
Okay.
This isn't the only bad act, prior bad act. There's several prior bad acts. And the other ones, he literally stuck a gun up to their faces and like different parts of their face and pressed the gun to their face. So I don't know why he didn't do that with this one. Maybe this was the first one, but a whole bunch of women are going to get called to the stand. So I hope they don't spend too much time on each woman, but they probably are. but I think it's gonna all tie together, and it's gonna all be relevant eventually after they tie them all together.
Now, before you filed this report with the Pasadena Police Department as an official business document, after you completed it, you read it over, didn't you?
Yes, I did.
And you checked it carefully to make sure that it was true, correct, and accurate. Is that not right?
That's correct.
You found no mistakes, no errors, nothing in there that caused you concern not to file it, correct?
Yes, sir.
And most importantly, you didn't find any omissions in this report that you would have wanted to include if it was important to the investigation, correct?
Well, reviewing the report, I believe there are some omissions in there.
Okay. Let me ask you this. In terms of omissions, do you have a list of those in your head?
No, I don't.
Okay. There's another kind of, this is what's called a crime report, right? Pasadena Police Department crime report?
The report forms a crime report, but it's not a crime report.
You may.
You say it's a crime report, but it's not a crime report.
Correct.
What does it say at the very top of the page?
This is the form that's used to document.
No, sir. What does it say at the very top of the page? That's my question.
Crime report.
Read the whole portion at the top of the page.
Pasadena Police Department crime report.
Okay. And then on page 3 and page 4, would you take that and would you tell and share with the jury, what does it say at the top of that?
Pasadena Police Department narrative report.
Okay. And the narrative report are the pages that are used to fill in or document the information that you obtain in the course of the investigation, correct?
That's correct.
All right. Now, there's another kind of a report that you're taught. There's a report called a supplemental report. You're familiar with that, aren't you?
Yes, sir.
Would you share with the jury, what is a supplemental report?
A supplementary report is written by any officers that might be involved in the incident to provide additional information, or an addition to the original report to provide additional information.
Okay. Did you said to me a key phrase, provide additional information. And there's information that may have been omitted from the original report, or information that you may have come to at a later time as you continue your investigation, things of that nature, correct?
That's correct.
In this case, you never filed a supplemental report. This report, this 4-page report that you previously identified here this morning, is the only report that you filed, correct?
That's correct.
And we are now in the year 2007, and that means that in the last 14 years, no supplemental reports were filed by you in regards to any information that may have been omitted in the original report, correct?
That's correct.
Okay, sir. So let's go back to what we do have, which is your official report that you've identified. In this report, as I understand it, the face page, you identify Ms. Melvin as a possible victim and Mr. Spector as a possible suspect, correct?
Correct.
And you have the date and the time, is that right?
That's right.
And if we turn over to page 2, and if you need to, by the way, at any time, if I ask you a question and you need to look at it to refresh your memory, with his honor's permission, I will ask to bring it to you to show it to you, okay? I'm not trying to trick you here. I know it's been a while. But actually, you've looked at this report before you testified here this morning, didn't you?
Yes, I did.
How many times in the last couple of weeks have you looked at it?
3 or 4 times.
Why'd you do that?
I looked at it before testifying each of the days that I came to court.
And that was in preparation for your testimony, correct?
That's correct.
Because this did happen some time ago, so you refreshed your memory by looking back at the report, right?
Yes, I did.
You were asked to do that by either Mr. Dixon or Mr. Jackson, is that right?
Yes, sir.
And you complied?
Yes.
Okay, so you have now a working familiarity with your report, although it was filed and authored 17 years ago, correct?
I believe it was 14.
14, excuse me, you're right. Okay, well, that's what happens when you get over 60. You have senior moments from time to time. All right, directing your attention to a portion report. On page 2, you indicated in your report that Ms. Melvin desired no prosecution or further police intervention. Isn't that correct?
That's correct.
And that's handwritten by you, right?
Yes, it is.
And further on down on page 2, actually, let me say, page 2 has several boxes in it. Is that correct?
Yes, it does.
And at the bottom, there's a box checked for evidence, correct?
Yes.
And there's another box next to it entitled solvability factors, right?
Yes.
All right, I want you to focus on those 2 boxes. In the box entitled evidence, it has a list of things, doesn't it?
Yes, it does.
I'm assuming you don't have those committed to memory.
No, I don't.
And I'm not trying to embarrass you, correct? All right. For example, blood, bullet casing, bullet projectile, clothing, fingerprints, hair, controlled substances, stains, tools, vehicles, etc., correct?
Correct.
And what box did you check in the evidence box section?
I don't believe I checked any boxes.
Okay, well, if I showed you a report, would it refresh your memory?
I do have a copy here, if it's okay to.
Certainly.
Walk back.
It's up to the court.
You may refer to your own copy if you wish.
Don't read it to us, just take a look at the box entitled evidence. Does that refresh your memory that you really did in fact check a box?
Yes, it does.
And what box did you check?
Other.
There's a box right above other, isn't there?
Yes.
And it has a title, doesn't it?
Yes, it does.
That box is not checked, is it?
No, it's not.
What is the word that appears next to that box?
Weapons.
Let's take a look at the box next to it, to the right. The box next to it, which is entitled solvability factors, also has a number of different boxes or sub-boxes which can be checked. Isn't that correct?
That's correct.
And for example, one says there is a witness to the crime, a suspect was arrested, a suspect was armed, a suspect can be described, et cetera, et cetera. There's about 10 or 12 boxes there, correct?
That's correct.
Now, in this particular section, solvability factors, you have no box checked, isn't that right?
That's right.
But you do have something you wrote in there, correct?
Yes.
You wrote the words, what?
Information only.
Share with the jury what that means.
Information only is that even though it's not a crime report, that this is a brief summary of what is called a suspicious search, a classification, which means that it's not being pursued for criminal prosecution. Therefore, it provides mainly the date, time of the incident, and a brief outline of the circumstances for documentation purposes.
Okay. So basically what you're doing is you're cataloging what occurred, but you're not referring it on for criminal prosecution. That's a fair statement, isn't it?
It's a brief summary outlining arrival, the circumstances, enough to document the incident.
In other words, it's for cataloging the incident, but not to be referred on for criminal prosecution, correct?
That's correct, yes.
Okay. Let's take a look at the first narrative page, or page of the narrative report, which is page 3 of 4, okay?
May I use my report? You may.
You have to ask the court's permission.
I gave it.
Okay,
Thank you.
Sorry. Okay, now, what I'd like you to do is, sir.
Yes.
You tell me when you're ready.
I'm ready.
Okay. I want to ask you questions, but I don't want you looking at your report unless you need to refresh your memory. If you do, let us know, and it's perfectly proper and appropriate for you to do that. But otherwise, I want you to testify from your memory, not by reading your report, okay?
Okay.
All right. On this page, there's another reference to what Miss Melvin expressed to you as to her desire that day, and that's found in the middle of the page, isn't it?
I'd have to look to see where it's at.
Okay. Why don't you take a look, and let me help you. It's paragraph 1, 2, 3, 4. And just take a look at it, read it to yourself.
Yes.
Okay. And by the way, this is all your handwriting on both pages, isn't it?
Yes, it is.
Okay. And your name again appears in the lower right-hand corner as reporting officer with your badge number on both of these pages, correct?
That's correct.
All right. Now, sir, as I read this, it indicates again that Ms. Melvin did not desire prosecution, seeking only the return of her property, correct?
That's correct.
I'd now like you to draw your attention, or turn your attention, if you would please, to the second page of the narrative report. Do you have that?
Yes, I do.
Okay. And once again, at the conclusion of your writing, your printed in the report, you have a section which is entitled recommendation, isn't that right?
That's correct.
Tell the jury what your recommendation was in this matter.
The recommendation was case to detectives for information only. Case to detectives for information only.
For information only, just like you had written on page 2 in the solvability factors section entitled solvability factors, where you wrote information only.
That's correct.
And I assume the answers would be, again, the same. It's for information only, not for criminal prosecution.
Yes, sir.
So Mr. Spector was never criminally charged as a result of any part of this investigation that you participated in the early morning hours of July 3rd, 1993. That is correct, isn't it?
That's correct.
Now, let's talk a little bit about another subject. As I understand it, by the way, when you met with Mr. Spector that morning, you indicated that when you first met with him, he was pleasant and was cooperative, and then at another time became irate. Is that correct?
That's correct.
All right. I assume you did not have any problems communicating with Mr. Spector in terms of him understanding you and you understanding him. You both spoke the English language that morning, right?
That's correct.
Mr. Spector was able to communicate with you, he responded to you, you spoke with him, right?
Yes, he did.
Okay. He wasn't drunk, was he?
I don't believe so.
Now, the purse that was found, as I understand it, that morning, your partner officer was Max Dahlstrom, is that right?
Dahlstein, yes.
Dahlstein, excuse me. And, Your Honor, let me spell that for Cindy, may I? It's, the first name obviously is conventional, M-A-X. Dahlstein is A-H-L, S as in Sam, T as in Tom, E-I-N as in Nancy. Okay. All right. And Mr. Dahlstein and you, or Officer Dahlstein, you were working as partners that morning, correct?
That's correct.
So it was Mr. Dahlstein who found the purse, right?
That's what I have in the report.
And in fact, he found the purse in the open, right out in the open, didn't he?
I don't know. I just have it listed as the living room of the residence.
Correct. And he found it underneath the dining room table in the residence, which is, if you recall, a fairly large room, right?
I know the house was large. I don't recall if the dining room was large or not.
Okay. You didn't see him find it?
I don't believe so.
But he never told you that it was secreted or hidden, did he?
No, I don't believe so.
Now, you indicated that at some point you said that you saw a shoulder holster. Is that correct?
That's correct.
And the shoulder holster that you saw that when you returned to the residence with the sergeant. You didn't see it when you were there the first time, did you?
To the best of my recollection, it was when he was being detained, when the sergeant was present.
Correct. So the first time, your recollection is he wasn't wearing it. You left, you indicated you left, waited for the sergeant, and then returned. And your recollection today is that you saw it after you returned with the sergeant for the second time. That's a fair statement, isn't it?
I don't know if he was wearing it the first time or not.
Okay, but you do remember it the second time?
That's correct.
There was no weapon in there, was there?
No, there wasn't.
And Mr. Spector never threatened you with a weapon, did he?
No, he didn't.
And in terms of the fact that even though you said you did somewhat of a cursive search, I think you said, or a casual quick search, you didn't find any hand weapon, did you?
No, he didn't.
And you never returned to the residence later that day with a search warrant to search it more thoroughly to find a weapon, did you, a hand weapon?
No, he didn't.
And Mr. Spector, he never threatened you with any weapon that day, did he?
No.
You never arrested him for robbery, did you?
No.
By the way, the pump shotgun that you've described in the residence, I know that it's a long time. You said you have only a vague recollection of it, but you don't know where in the residence, correct?
Correct.
Did you take that with you that day? You did not, did you?
No, we didn't.
The shotgun was left there, correct?
Yes.
With Mr. Spector.
That's correct.
All right. Now, I want to turn our attention now to a subject that Mr. Dixon brought up. Mr. Dixon asked you whether or not you looked at Miss Melvin that day, and you did look at her. You looked at her from time to time throughout the course of the incident, correct?
Yes.
I want to turn your attention to specifically Miss Melvin's head, okay? You with me?
Yes.
Okay. You described there was something that she did. She parted her hair, she leaned forward, and your recollection was she was showing another officer something you're just not really clear on it, correct?
I'm not sure what she was doing, but she did part her hair and lean forward, and someone was looking at her head.
Well, let me ask you this. You noted in your police report, as you say, what happened that day. You talked about the incident. You described the incident, correct?
That's correct.
Is there anywhere in your police report, sir, that it reflects that you or your partner officer, Max Dalston, saw any hematomas, any contusions, fancy words for saying bumps or lumps on the head? There isn't, is there?
No, there isn't.
Is there anywhere in this police report, which was, by the way, this was written right after the incident, correct?
I believe shortly thereafter, yes.
Okay, within a matter of hours, maybe even minutes, correct?
Probably, yes.
Very close to when the incident occurred.
Yes.
Is there anything in here that indicates that you observed or any other officer observed a laceration, a cut? There isn't, is there?
No.
Is there anything in this report that you authored that indicates Miss Melvin was bleeding that morning from her head in any way? There is not. True?
True.
And finally, is there anything in this report, your official business record crime report and narrative report, that reflects that she was applying Neosporin to any head injury that morning? There is not, is there?
No, there isn't.
As a matter of fact, you were interviewed on April 29th.
Dude, don't ask a question, answer it, and then ask him if it's true. Just ask the damn question.
2004, correct? You were interviewed by Detective Richard Tomlin from the Los Angeles Sheriff's Department, isn't that right?
I believe it was sometime around then.
Okay. Your Honor, may I approach for refreshing memory?
If he needs to have his memory refreshed.
If I showed you Detective Tomlin's report, might refresh your memory as to the day when you were interviewed? Yes. May I approach?
Either that or you can stipulate that that was the date he was interviewed.
Fine. Okay.
So stipulated? All right, ladies and gentlemen, you'll accept that stipulation as a fact proven to you that that was the date this officer was interviewed. You'll be instructed at the close of the trial as to how to evaluate and accept stipulations. You may proceed.
Thank you, Your Honor. And on that date, apparently in the afternoon hours, about 2:50, you were interviewed, were you not?
I believe both my partner and I were both interviewed.
Well, I'm just asking about you. Were you interviewed?
Yes.
Okay, and you were interviewed after Mr. Dalston was interviewed, correct?
I believe we were both in the same room. I don't recall.
Oh, all right.
But I believe we were together.
And you were interviewed by Detective Richard Tomlin from the Los Angeles Sheriff's Department, one of the case agents in this case, correct?
Yes, we were.
And Detective Tomlin, he asked you about that subject matter, any injuries to Miss Melvin's head, correct?
I don't recall, but he probably did.
Okay. Do you recall what your answer was when he asked you whether or not you saw any obvious injury to her head when this incident occurred?
No, I don't.
You may.
Sir, let me show you Detective Tomlin's report. You see it's called a Sheriff's Department Supplementary Report, and it's authored by Detective Richard Tomlin. Would you just take a look at the last paragraph and just read it to yourself if you would? We can sort of move it along if you just read the last couple of sentences.
Yeah.
Yes.
You've now read that?
Yes, I have.
And in fact, your memory is now refreshed. That Detective Tomlin did ask you about whether or not you saw any obvious injury to the head, correct?
That's correct.
What'd you tell him?
I told him I didn't see any indication of any injuries.
At that time, you had been in law enforcement about 12 years, 12 and a half years, correct?
Correct.
And you had knowledge at that time that in the course of an investigation, if you believe a crime has been committed, you want to do everything you can to preserve the integrity of any evidence that may develop at that time. That's a true statement, isn't it?
That's correct.
One of the ways law enforcement preserves the integrity of evidence is through the use of technology. Isn't that true?
In some cases, yes.
One form of technology, for example, is audio recordings or video recordings, correct?
That's correct.
Another form is using a camera to take pictures, correct?
Correct.
Are there any photos to your knowledge that exists of Miss Melvin's head from that morning?
I don't believe we took any photographs.
Photographs. In other words, let me ask it this way. Let me withdraw the question. Did you take any photographs of Miss Melvin's head that morning?
No, I did not.
Did Max Dahlstein do that?
I don't believe so.
Did the sergeant do that?
I don't believe so.
And the reason is because there was nothing to photograph, correct?
I don't know that.
Officer, if there were injuries, bumps, a laceration, bleeding, and the person told you that they had sustained these injuries by an individual striking them with his hand, which held a weapon, and the weapon struck this person, you would have photographed that to preserve those injuries, correct?
Overruled. If he had some responsibility or felt he should have, he can answer.
If I was told that, yes, I would photograph that.
And you didn't, correct?
I wasn't told that.
Okay. In fact, let's take it to the next step. If you had seen, strike that, if somebody had told you that they had been struck with a hand that held a handgun, a steel handgun, hit in the head, and showed you that there were bumps or contusions, a laceration and bleeding, and that person told you, I don't want to prosecute, I don't want to pursue this, you as an investigating officer would have listened to that, but you would have ignored it and conducted your business as a law enforcement officer by gathering the evidence and making a decision whether or not to present that as a case to the DA's office. That's a fair statement, isn't it?
Objection calls for speculation, assumes facts not in evidence, and proper.
It's compound. The objection is sustained.
I'll break it down. If you had seen somebody, strike that. If a person had contacted you and told you that they had been struck by a weapon or the hand holding a weapon in their head, you would have conducted further investigation, correct?
Yes.
If you were told that that person also had had her purse taken from her in the course of this, you would have conducted further investigation, correct?
That's correct.
If you had retrieved the purse, or one of your colleagues had retrieved the purse and returned it to the individual, and that person had indicated to you that they desired no further prosecution, you would have still continued to investigate, correct?
That's correct.
And sir, if you had determined that in fact a robbery had occurred, or an assault with a deadly weapon had occurred, or an assault with intent to commit great bodily injury had occurred, even though the potential victim had told you they didn't wish to prosecute, you would have rejected that request and presented it to the DA's office for them to make a determination as to whether or not a crime had occurred, correct?
Objection, speculation, argument, and comment.
Overruled. I believe you can answer that. You feel you're able to answer that question?
Yes, sir.
You may answer.
We would actually document the incident according to the crime that we were looking at, if all the elements were there, and then that would be presented to the detective section who would do the filing with the district attorneys if it was warranted.
Okay, help the jury here. I know what you mean. When you say present it to the detective section and present it for filing, there's a procedure, a process that goes through when cases are brought together and brought to the DA's office for when you say filing, correct?
Correct.
Right. Tell the jury, if you would, or explain to the jury, please, what that process is so they'll know what we're talking about.
After the report's written, it's reviewed by a supervisor. A determination is made at that point whether all the information is in the report. The report's then forwarded to the detective section. They evaluate the report and conduct any follow-up that's necessary. If the case warrants filing with the district attorney's office for prosecution, then they pursue prosecution through the district attorney's office.
Okay. And in this instance, with the last 4 questions I asked you, if that were the case, you would have forwarded this on to the Detective Bureau for them to bring it to the DA's office to decide whether to issue a criminal complaint or not, correct?
Correct.
You didn't do that in this case, did you?
No, sir.
Your Honor, may I have the court's indulgence for a moment, please?
You may.
Thank you. Okay. I want to turn to the last area of inquiry this morning, Sergeant Russ, and I want to hear your answers up to now. I want to return to your testimony a little bit earlier about what you included in your police report, okay?
Yes.
Does your 4-page police report, the official report that you filed regarding this incident, does it contain any information about Mr. Spector consuming a 5th of vodka in a short time? It does not, does it?
No, it doesn't.
Your report, again, it does not contain any information, does it, that Ms. Melvin claimed that Mr. Spector pointed the gun directly at her, correct?
I'd have to look at the report in terms of.
Please do.
No, sir, it only says that he displayed a gun.
Displayed a gun. The word display is different than the words pointed at, isn't that true?
That's correct.
The report contains no statement attributable to Ms. Melvin that she was terrified during this incident. Isn't that true?
There is no statement like that.
The report does not contain any statement by Ms. Melvin that something sharp hit her in the head, correct? That's correct. The report does not contain a statement that Ms. Melvin said that Mr. Spector was seated on a stairwell or a staircase with a gun pointed at her, correct?
That's correct.
Is there anything in the report that Ms. Melvin indicated to you that she could feel the welts on her head and that there was blood on one of them from a laceration? There is not, is there?
No, there isn't.
Sergeant Russ, there is nothing in your report to indicate that Ms. Melvin threatened to have charges pressed against Mr. Spector that morning, correct?
That's correct.
When you came up to the residence with the sergeant, you indicated your recollection was that you came through either the back door or the side door and Mr. Spector was there, correct?
That's correct.
And you started talking with him.
I believe we were engaged in conversation before the sergeant arrived.
When you came up to the door, you did not hear Mr. Spector on the phone talking to somebody, laughing and joking, did you?
I don't recall that.
It's not in the report, is it?
That's correct.
There is nothing in the report that reflects that Mr. Spector threatened to sue you, is there?
No, but I do recall him making a comment like that.
Okay, but it's not in the report, is it?
No, it's not.
In fact, there is nothing in the report that Ms. Melvin threatened to press charges multiple times that morning, is there?
No, there isn't.
None of those subject matters that I just listed for you appear in your official police report that you filed at the Pasadena Police Department after this incident, correct?
I'm not sure if everything that you asked, I believe there was one question you asked that was actually in the report, the displayed versus pointing. And the other items were not.
The word displayed was in the report. The words pointed at were not.
Correct.
Okay. Other than that, the list of everything else none of those subjects, none of those points appear in your report, correct?
No, they don't.
Your Honor, may I have the court's indulgence for just a quick moment, please?
You may. Thank you. Redirect.
Officer, if you're out in the streets in patrol, somebody displays a gun at you or points it at you, it's both pretty serious situation, isn't it?
That's correct.
I noticed during your cross-examination with Mr. Rosen, you said, and I want to ask you about this, it was a crime report, but not a crime report, correct?
Yes.
And what did you mean by that?
We use this form to document, this is our formal report form that's used to document information that's cataloged inside the police department. Under this particular case, the form was used to document what we list as a suspicious circumstance, which is an incident that doesn't amount to a crime, but it's done for the purposes of cataloging the date, time of occurrence, the people that are involved.
And the reason that it wasn't a crime report or didn't amount to a crime, did that have anything to do with the fact that Dorothy Melvin was so clear about the fact that she didn't want to prosecute?
Yes, her not wanting to prosecute was, I believe, was part of the reason why it was listed as a suspicious search versus a robbery report.
And she told you not only did she not want to prosecute, but told you exactly why.
That's correct.
It would have to interfere with, well, it might bring embarrassment to her employment.
Not those exact words, but she felt that it would bring a lot of publicity for her and for Joan Rivers, also for Mr. Spector.
And she just wanted her handbag back, isn't that right?
That's correct.
Okay. So you also said that the report was for information only. Same reasons why?
That's correct.
So because it was for information only, not really a crime report, is that a reason why it was not as complete as if it had been a crime, if you were writing a real crime report?
In most cases, yes. The other information that was brought up in terms of the questioning, I don't recall that information ever being told to me.
But you were only one of two, and then later on, 3 officers at the scene.
That's correct.
And did you from time to time see either the other 2 officers, your partner, or the sergeant talk with Dorothy Melvin?
I recall both of them talking with her, but I don't recall what they were talking about.
All right. At times out of earshot from you?
Sometimes, yes.
But notwithstanding the fact that this was for, let me withdraw that and ask you this. It wasn't your job at the time to take any report to the DA's office, correct?
No, it wasn't.
That was, I think you indicated, Mr. Rosen, the job of the detective division.
They would base their filing the case on the reports that we write as officers.
And did you tell Mr. Rosen that notwithstanding the fact that this was for information only, it still went to the detectives?
No, I did not.
Did it go to the detectives? Was it filed at some point?
Yes, as stated earlier, it was sent to the detectives for information only.
But detectives did have this on their desk at some point?
I believe so.
And notwithstanding the fact that it was for information only, you did have a lot of facts in your report, isn't that correct?
Yes.
The time and date of this, 5:15 in the morning?
That's correct.
And who was involved? Phil Spector, Dorothy Melvin, right?
That's correct.
That it was a possible armed robbery?
That's correct.
And that Phil Spector forced Dorothy Melvin to leave her handbag behind as he displayed a gun at her? That's in the report, isn't it?
That's correct.
And that at some point, Phil Spector denied knowledge of the purse or the handbag, and then later became irate and demanded that you leave his residence.
That's correct.
And at some point, you had to handcuff him. All this is in the report, just for information, but it's in the report, correct?
Yes, it is.
And the fact that the handgun was, or excuse me, that the handbag was eventually found, correct?
That's correct.
Let me ask you one last couple questions. Mr. Rosen asked you if you thought Phil Spector at this time when you contacted him at his home was under the influence of alcohol. I thought you hesitated. Did you?
The statement is stricken. The jury's admonished.
Did you test him in any way for that?
No, I didn't.
And in fact, if it'd been another situation, driving a car or something, there are a whole set of tests that you might give, like field sobriety tests, correct?
That's correct.
But you didn't in this situation.
No, sir.
Because he wasn't driving a car.
That's correct.
And wasn't the focus of your interest there.
No, it wasn't.
Could I have a moment?
You may.
Thank you.
Thank you. Recross.
I'm not going to say a few questions. Anytime a lawyer says a few questions, you know you're in trouble. Mr. Dixon asked you the question, displaying a weapon and pointing a weapon are both serious, correct?
That's correct.
Okay, but certainly not equally serious. If you determine in your investigation as a law enforcement officer that somebody points a weapon, a loaded weapon, directly at a person, that's far more serious in your mind professionally than if somebody just takes out a gun and displays it, correct?
That's correct.
Okay. You indicated that your recollection was that Ms. Melvin didn't wish to prosecute because it would have brought a lot of attention to her, Ms. Rivers, and Mr. Spector, correct?
That's correct.
Now, her wishes not to prosecute certainly don't override your investigation if you believe that a crime is committed, correct?
It depends on the information that's provided regarding the crime.
Well, if you believe in your mind that a 211 or a 245, if you believe in your mind, if you believe that a robbery or an assault with a deadly weapon has occurred and you're investigating it and the person who you believe is the purported or alleged victim says, well, I don't want to prosecute, that's not going to stop you from furthering and conducting your investigation, correct?
That's correct.
In fact, it's been your experience that prior to July 3rd of 1993, you've had instances where people have said, I don't want to prosecute, and you go ahead and take the report, conduct your investigation, forward it on to the Detective Bureau, and it does get filed by the DA's office, right?
Yes, sir.
That's not unusual, is it?
No, it's not.
Mr. Dixon asked you whether or not, maybe I misheard this. Did he ask you whether or not eventually a handgun was found? I may have misheard it.
I don't believe so.
Okay, because it wasn't, was there?
No,
There was
it
no
wasn't.
handgun found that day, right?
No.
Okay. Finally, he asked you, did you test Mr. Spector for alcohol? Recall that?
Yes.
And he asked you if, in fact, it was, for example, somebody driving a vehicle. There's a whole battery of tests you can have somebody attempt to perform, which are called FSTs or field sobriety tests, correct?
Correct.
And you didn't have Mr. Spector perform any field sobriety tests, correct?
Correct.
You already told us under oath that you didn't believe he was drunk, correct?
Correct.
He wasn't falling down, was he?
Actually, I'd like to correct myself. I believe I said I don't recall if he was drunk.
Okay. If he was drunk, you probably would have noted it in your report. That would have been an important point, correct?
I'm not sure, based on a suspicious search, if I would have noted that in the report.
All right. Well, it's not noted in the report, is it? There's nothing in the report to indicate that he had been drinking, that he was drunk, that he was under the influence of alcohol, correct?
That's correct.
And finally, if you had wanted to conduct a series of FSTs or field sobriety tests, or if you wanted to arrest Mr. Spector because you thought he was a criminal and done something wrong, you could have taken him to the station and also administered other tests, like a blood test or a breath test, correct?
We don't usually do that under these kind of cases.
But you could have done it, right? Nothing would have stopped you from doing it if you wanted to, right?
Correct.
You didn't administer any field sobriety test at the residence, did you?
No.
And you didn't take him anywhere else for further testing, correct?
That's correct.
Nothing further. Thank you. Redirect.
No, thank you, Your Honor. Nothing further.
Thank you. Subject to recall, you may step down. Thank you for being here. Cindy, do you need a few minutes? All right, ladies and gentlemen, we'll be in recess for approximately 10 to 15 minutes. Thank you. Keep in mind the admonition.
Okay, guys, that's all we're going to do for this morning because I got to go take a nap. I'm so tired. I don't know why I'm so tired. I took a nap yesterday. I went to bed at my normal bedtime and I overslept this morning. So I don't know why I'm so tired. I should be well caught up on my sleep, but I'm exhausted. So I'm going to go take a nap and then I'm going to wrestle the little butt heads into the car so I can get them to the vet to get their nails done. I really wish they would let me do it. It would be so much easier if they would just let me do it, but no, I can't even touch their paws. Little stinkers. Okay, guys, we'll do this again in the morning since they're not going to do another Karen Reed hearing tomorrow. They were supposed to, but Bev changed her mind. So they're not going to do more Karen Reed until the 18th. So I don't know what we're going to do. But I'm going to take a look at the original corn rake murder trial and see how long it is. And if we have time, we might do that before Karen Reed starts on April 1st. Because I'm really curious now. Because there was not enough evidence in that post-conviction relief hearing for me to know. And I didn't see the original trial. So I don't know if the jury got it wrong or not. A lot of people think that they got it right and that he's right where he belongs. And I can understand why they think that way, because if she was cheating and he was afraid that he was going to lose half of everything in the divorce, that's a pretty good motive. It also, I mean, it doesn't mean having motive doesn't mean that he did it, of course, but so we might do that one. I don't know. But as always, just make sure your bell is clicked for notifications so you know what we're going to do. And I will see you guys next time. Thanks for coming out. I love you guys. Have a good day. Bye.